Testing 1, 2. Testing 1, 2, 3. We're going to wait another minute. Be 8:30 on the dot. Mhm. It's taking a long time for a minute, hasn't it? And you're waiting. All right, 8:30. You know, I need to turn my phone off. Be embarrassed. I'll get
Just turn it on silent.
That's what I'm doing. See what happens. Good morning. I'm glad all of you all are here. On behalf of Tristan Armer and Myra Cunningham in the firm of Heidelberg Steinberger Burrow Armer and the Gulf Coast Human Resource Association, we welcome you again to one of our annual meetings on employment law and workers' comp. We hope each of you take a little something away from what maybe something you didn't know. There's going to be a lot of things we present that you do know, I believe, but I think we have some extra. I want to thank the Jackson County Chamber of Commerce for the opportunity for us to be in this building. And I want to thank those who have helped put this together, with Caitlin Winstead and Christy Bloom and Heather Angles, who's been helping too. And so we're going to ready to go. I want to commend each one of you for being here. I believe that, of course, some of you may need to be here for your adjuster's hours or your firm hours, but even so, I commend you for being willing to learn. Knowledge is power. I think all of us recognize that. And you are all taking time out of your day, and all of you that are on video, the same thing. You're taking time out of your day to learn something you may not know before, to help you in what you do every day. For those of you who are here, I guess you know the drinks and coffee are in the back. The restroom is back to the left. Turn left and turn right. For those of you that are home or at your office, I really encourage you to download the screens. It's a PowerPoint. It's easy to find. I think that might be a benefit. And also there's an agenda that you can use that I think will help you as well. For those of you who are filing for credits online, you can go and do it online. We have a form here in the back. If all of you need credits, make sure you fill out that form as well. And then later on in the day, we have an exit interview thing we'd like you to fill out for us so we can learn what we're going to do in the future, next year or other times. Also, if you're warm or cold, let us know. We're already warm. I'm a little warm up here, so we're going to cut the air down a little bit more. I got here this morning, it was really warm, and I cut it down to 70, I think, but we'll cut it down so we can all be comfortable. What screen? There you go. All right, I've already introduced ourselves. I'm Carl Steinberger, Tristan Armer, and Myra Cunningham. We're going to be making the presentation today. There is a guidebook that we publish every year, and we keep it up to date. And I encourage each of you to go online and download that. I think it might be a benefit to you. We update it. It addresses all of the different issues that we're presenting today and more. There's a lot more in our book than there is what we're going to present today. You can use it, as I'll explain a little later. It's really helpful as far as how to understand workers' comp. I'm going to now turn it over to Tristan, who's going to do elements of the claim.
Let's do that a little bit. I'm a little taller than Carl here. I'll step back. What we're going to cover now, a basic workers' comp claim. I think if you're an adjuster, if you're an employer, before you ever say yes, you want to go through what we call the basic elements of a claim and see if anything's missing. Because if it's missing, you don't owe workers' comp benefits. However, if an employee shows each and every one of these claims, all right, you probably owe workers' comp benefits, and then you need to turn your attention to whether there's a affirmative defense and or that you don't overpay benefits. I think in my experience, every employer pretty much agrees to pay everything they do owe. I've never had an employer come to me and say, hey, we don't want to pay what we owe, but we don't want to pay any more than what we owe. I think that's a fair way of looking at it. There's three elements to every workers' comp claim that must be present for it to be, as we use the word, compensable, something you got to pay. It's got to be a job-related injury that has to result in some disability, and there has to be a link, causation, we say, between the injury and the incapacity or disability. Claimant, the employee, bears the initial burden of proof. They must give you some facts, some evidence that meet all three of these basic elements. In Mississippi, there are a few little special cases that go beyond the basic three elements. One is called the found dead presumption. And that is not that someone fell dead. It is that if an employee is at his regular place of work, doing what he's supposed to do, and you come upon him and he's dead, then there is a presumption, not conclusive, but a presumption that he died in the line and scope of his employment. Presumptions are like the presumptions of innocence. You know, you start with it, the other side can prove you're guilty, and of course you're guilty. And it's the same. The employee is presumed to have died in the course of their employment. Now, you get an autopsy and it says it was purely a heart attack and there's no extra exertion, things of that nature. You can rebut the presumption with evidence, but the employee starts with the presumption if he is found dead at his job. Sorry, I got distracted by the train coming by. And as we talked about heart attacks, it's another special case. Mississippi does, from time to time, find a heart attack that occurred in the line and scope of employment to be compensable. The employee must show that there was also, in addition to having a heart attack on the job, some unusual exertion or some unusual event that caused extra stress on him to trigger the heart attack. Now, what usually happens is it's hot because it's Mississippi, or they're in an attic and they had to climb stairs, and some minimal exertion. And what you would do ultimately is go to the physician and say, hey, we allow apportionment. I think Carl hit on that a little bit further, go into more detail on what apportionment is, but it'll apply to a heart attack case. But you'll have to pay medical benefits. Usually when someone has a heart attack on the job, they can show any exceptional exertion. Occupational diseases, they're treated a little bit differently. This is your like asbestosis. There's certain burdens of proof that the claimant has to have. There's a little extra proof that they have to give you as far as causation goes. But that's how we handle occupational diseases in Mississippi. And then the last one, the one I always get, yes, in Mississippi, under Mississippi Worker Comp Law, if you have an emotional distress injury, it can be compensable. They're broken down into three categories, and that is where you have a mental injury that manifests itself in a physical symptom. And so it may be like they have an outbreak of hives from stress, things of that nature. That can be compensable on basic evidence. Then you have what we call the physical mental. Now, physical mental is maybe you suffered an injury to your arm and you're so stressed out or have post-traumatic stress disorder on it. And in those situations, the employee must provide clear and convincing evidence, a heightened standard that the emotional distress injury was caused or contributed to by the physical injury before you have to pay, for the psychologist and the psych meds. And then mental, that is where you have nothing but a post-traumatic stress and or nervous breakdown type mental injury with no physical manifestations. And it's the same. The heightened burden of proof is applied. The employee must show clear and convincing evidence, not just a presumption evidence, clear and convincing evidence that the job caused the injury and the mental injury itself is job related. I had one of these once, a trucker was in an accident, wasn't his fault, ran over some people. He got out of the truck. He found the dead bodies underneath the truck, freaked him out so bad he never left his house again. Mental injury, totally in his head, true disabling type injury. He wasn't leaving his house. We put surveillance on him. He never left, grew a beard, got crazy. Feel bad for the guy, but that was a true mental claim. We paid workers' comp benefits for it. The benefits, we always throw that word out there, and most folks that deal in workers' comp know what benefits are. We break them down into the disability category or indemnity benefits. This is the 2/3 your paycheck for a certain number of weeks that you're unable to work, or your earnings from working have been diminished. Of course, medical benefits. And as I was telling somebody this morning, in the last 5 years, and it's never going to change, the cost of medical benefits on your average comp claim exceeds indemnity costs on your average comp claim. Medical benefits is where most of the money gets spent these days, paying the doctors and the therapists and the pain managements and the pharmacy bills and all that other stuff. There are benefits for what we call voc rehab. Correct me if I'm wrong. It's either $10 a week or $20 a week for like 26 weeks. And here's the thing, I've never seen it awarded. I think this was something that maybe happened back in the early 90s. And it really is, it's there. I don't know if anybody gets them anymore, but know they're there. I doubt you see them. Death benefits, if somebody is killed in the line scope of their employment, there's some extra benefits in addition to kind of 2/3 the paycheck. And it depends on, you have to have dependents. If you have a widow or wife and she depended on you for support, you're dead, she'll get, I can't remember the exact percentage. I guess 35% of your average weekly wage. If you have children with her and they're dependent, it's 10% for each child until you hit the cap. If you have other family members that were dependent, they also can get, they have to prove their dependency. They can receive some of those payments. And then you also owe funeral expenses, a widow's allowance. And if there's no dependents, meaning if the single guy with no wife and kids gets to fish all the time and play golf and relax, if he gets killed at work, the employer has to pay money into the second injury fund. I think it's $7,500. So disability, again, this is the paycheck the employee gets if they can't go to work. We categorize these into temporary or permanent, total or partial, or scheduled or unscheduled. And just real quick, temporary is when you get hurt, the theory being while you're off from work, usually totally, because the doctor says, hey, look, I got to get you healed up. All right. But I know within 2, 3 months, 6 months, I'll have you as good as science can get you. All right. And that's what we always throw around the term maximum medical improvement. Well, during that period, we call that the temporary disability period. Now, during temporary disability, let's say you can't work at all. Well, we call that temporary total. You get 2/3 your paycheck subject to a cap for that period of time till you hit MMI. But let's say the doctor says, look, I'll let you work 20 hours a week. All right. So now you're 50% loss of wages. Well, what you get is TPD, temporary partial disability. You get 2/3 of the difference. So if you lose 20 hours a week, $10 an hour, it's $200. You'd get 2/3 of the difference, was $166. That's temporary partial. That's, again, one of the great benefits of returning all of your employees to light duty work. You will cut your work, you'll save that 1/3 of their wages. They'll be working, they'll be productive for you, and you will not pay them about 1/3 of whatever the loss is. Total or partial, total disability, can't work at all. Partial disability, some work, but you can't earn the same wages that you earned before. And then scheduled and unscheduled, there's a list of about 14 body parts in the statute. I think way back in the 50s, they called it the butcher's meat market of limbs was the term thrown around. And it's like an eye, arm, a leg. And they have a scheduled or fixed number of weeks that benefits are paid. So if you have an arm injury and it's just an arm injury, it's 200 weeks of benefits. So you go to the doctor, he says, well, you're an MMI, and I think your arm is, it's about 90% as good as it used to be, or it's 10% loss. Well, 10 times 200 is 20 weeks, 2/3 your paycheck. Say make $1,000, subject to your caps, that's 585 times 10, that's $5,800 you owe for the limb. And so scheduled versus unscheduled, it's scheduled or less. Unscheduled is typically your back or anything that's not in the the butcher's meat market list of limbs, as they used to call it. And that is 450 weeks of benefits. So as you can see, if the employee is off schedule or unscheduled, the cost of indemnity goes up almost double. Again, we have a max in this state. We have both a weekly max and a hard cap for indemnity benefits. The weekly maximum is you can make $3,000 a week. You are a high earning physician. You get your leg chopped off, tripping over something and whatever. You will only get $585.82 per week under workers' comp. It's a hard cap. Now, in Mississippi, we also have a maximum exposure cap, which means this too. You only will ever get or pay out to your employees 450 weeks of benefits at $585.82 per week. That means that no matter how injured or badly injured a Mississippi employee is, the total indemnity payment would be no more than $263,619. You can get to that cap. It's not a 450 week cap. Theoretically, you got a low wage earner, maybe minimum wage, and they get hurt, and maybe it takes forever for them to heal. They literally could get 450 weeks of temporary total disability, and it would be about 100 grand. And then the doctor says, he ain't never will work again. And so he could get 450 weeks of permanent total disability, which is another 100 grand. That's 200 grand. That's less than the cap. So he's 900 weeks of benefits, but you never pay more than the gross dollars that are computed by taking the weekly maximum times 450 weeks. I hope I've explained that where it makes sense. So again, we talked about temporary total already. The waiting period in Mississippi is 5 days. That means if your employee is injured and can't work for 4 days, you still don't owe him any workers' comp. On the 5th day, where he has, and here's a day is any day the worker does not earn his usual wages. So if he misses 1 hour on Tuesday, it's a day of disability. If he misses another hour on Wednesday, it's another day of disability. Just 1 hour. Just 1 day of diminished earnings counts as a day of disability. And once they hit 5 days, you pay them for that day. Pay them for day 6, pay them for day 7. You pay them per day until they hit day 14. Once they hit day 14, you got to go back and pay the first 5 days. And then you'll pay probably bi-weekly thereafter. So that's how the waiting period works. For these small, short, temporary injuries, you may not owe any indemnity. The employee may say, man, I missed 3 days of work. You can kind of go, come on back. Open arms, get back to work. You don't owe workers' comp indemnity benefits, all right? Permanent total, we talked about that. Permanent total is assessed once you hit maximum medical improvement. If the doctor says, look, there's no way you're going to return to any gainful employment, it is an award of 2/3 the average weekly wage, subject to a cap for 450 weeks. Permanent partial, we covered a little bit already. That being mostly your scheduled benefits, the body parts. And know this, in Mississippi, and this is where it's a little unique to other states. I'm in Alabama a lot. I practice over there too, and it's much different. In Alabama, the schedule means the schedule. In Mississippi, a scheduled member indemnity award is not limited to the anatomical impairment rating. So back to the example I gave you earlier, the doctor says, hey, look, the arm's 10% impaired or 90% as good as it used to be. But let's say I am a sheet metal worker and I can't go back and do sheet metal work because my arm's tore up. Well, at that point, I have a vocational loss in addition to my anatomical impairment. The physical impairment is equating into a greater loss of earnings. In Mississippi, we call that industrial loss of use. And that is computed by what jobs can you do now as opposed to you couldn't, what are the usual tasks of your occupation, and I hope there's no administrative law judges watching this right now, but they kind of do this. They feel the wind and they say, I think your industrial loss of use is 40% or 50%. It's usually 3 to 5, 6 times the anatomical impairment rating. And so again, instead of 10% times 2/3 your paycheck, now it's 40% times 200 times 2/3 of your paycheck. So that's how they increase the indemnity award on a scheduled member injury. It's called industrial loss of use. when I deal with adjusters who are new to Mississippi or, they're used to other states, that's a fresh concept. It's kind of unique. Alabama is really a strictly to the anatomical impairment state, and Mississippi is different that way. The test is, did they return to their same job making the same wages? If you return to work, you can argue there's no industrial loss of use. But the other side's going to say, hey, he's got restrictions, the employer's just being nice to him, things of that nature. And again, administrative law judge kind of feels the wind and awards something accordingly. Medical benefits. Medical benefits are owed for life. We always say get the medical benefit, it has to be reasonable, necessary, and causally related to the employment or injury. What's reasonable? Well, pigs get fed and the hogs get slaughtered. The physicians want to restore someone to the maximum amount of health they can. I think physicians, good ones, they're willing to try a lot of stuff to heal a patient, and good for them. But we can't be an open-ended trial book of money for medical treatment either. And so there are a lot of fights and squabbles over what's reasonable and necessary. Medicine has changed. When they wrote these comp statutes about medical, the notion was, you're just a regular old dude out in the country and you get hurt at the factory and you go see your family doctor and he says, oh Lord, I'm going to write a letter to the specialist up there in Jackson and send you for your surgery and come on back. And back then they didn't have a lot of pain medicine and they didn't have a lot of therapists, and you kind of just, suck it up. That's life. Medicine has totally changed. The statute is 40 years, 50 years older than modern medicine. Modern medicine is now you kind of go to someone that's more akin to a hospitalist than a family practitioner, and then he sends you to the ortho for surgery, who then sends you to a pain management doctor, who sends you to specialized therapy, who adds devices, TENS units, and so the world or globe of medical benefits has really, it's gone from this little linear course into a hub and spoke course where there are a lot of spokes. What do you do as an employer or carrier to try to keep things quote unquote reasonable? Well, you've got utilization review. You can send it off. There's 3 layers of review. We could spend an hour on it or not, and I'll tell you why. In Mississippi, if you have a non-contested or no petition filed claim, utilization review can say, look, this is excessive, this is unnecessary, it's been reviewed by a physician, now we're not doing it. But once it's a petitioned claim, once it's litigated, the administrative law judge said it to me one time. He said, listen, I'm not a doctor. And when a doctor says he needs this treatment, who am I as a lawyer and judge to say no? And what you must do as an employer then, or carrier, is bring your own doctor. He says, listen, this is not how we normally treat this injury. This is excessive. This is unnecessary. It's not going to do any good. It's not going to improve his outcomes. So now you have 2 doctors. One says yay, the other says nay. And what the administrative law judge says is, well, let's just find us a 3rd doctor to break the tie. And that is called the IME, or independent medical exam. And whatever the IME doctor says, chisel it in stone next to Moses' tablets, because that's what's going to happen in the case. Okay, the IME doctor wins. Give me a little help on that. There we go. Whoops. Mississippi ex parte communications with the physician. You can talk to the doctor all day long as the employer and carrier, unless and until the claimant files a petition to controvert. All right. Once the lawsuit for workers' comp benefits is filed, no more ex parte communication. Ex parte is the old lawyer word. We like to use Latin, makes us look smarter, but it means one party, right? As an employer, if there's no petition filed, you can have a nurse, you yourself, you pick up the phone, call the doctor, say, what do you mean he's going to be off work for 3 weeks? I got a light duty job for him. Bring him on back. Clear him for light duty. You can do that. No problem. And you should. You're allowed to do it. But I'll tell you this, I've had this 2 weeks ago. The adjuster, she's out of Alabama, but she does Mississippi too. And she said, why did they sue us? We've been paying everything. I said, this rule right here. They didn't want ex parte communications with a doctor. So they went ahead and filed a petition to controvert early. nothing's really in controversy, but it stops the employer carrier from having ex parte communications with the doctor. So that's how that's been working out for us. It's sort of accelerated people filing actual litigated lawsuit. And one other thing too, once it's litigated, if you write a letter to the doctor and you copy the claimant or the claimant's lawyer on that letter, that's not ex parte. Okay. You are communicating in front of the employee. So again, as an employer carrier, if you want that doctor, you got him off work till the next visit, but he's pretty close to healing. We got a light duty job for him. Here's the job description. Can he come back and do this light duty job? CC, claimant's lawyer. That's okay. That's not ex parte. All right. Death benefits, we touched on this earlier. Again, it's a dependency statute. No, and here's the numbers too, because I don't have everything memorized. $1,000 is the widow's allowance. You have to buy them was it 3 or 5? They raised it. It's a $5,000 funeral. I don't know what a $5,000 funeral looks like, but that's what you buy them. And again, if there's a dependent widow, it's 35% of the average weekly wage. Memory still worked. And then again, children, 10% for each. And grandchildren, brothers, sisters, parents, if they're dependents, they can acquire indemnity death benefits also. All right, now that you know what you have to do to pay, what they have to show to pay, Carl is going to give you what we call the affirmative defenses, which are ways to say, all right, you started here with your presumption. Now we're going to see if we can reduce it. Yes, sir.
Thank you, Tristan. So I mentioned the book before that you can download. In that book, there's an index. And in that index, it lists what we believe is every way under the Mississippi law, which is a statutory law. Everything having to do with workers' comp comes from the one statute. It lists all the different ways, and that's what we're going to talk about today kind of quickly. And it's a good checklist. In workers' comp, there's pretty much a presumption of compensability. You hear about that. Statute in 2012, they tried to change it and said it would be a level playing field. But my experience with the judges and the courts are still, they want to try to help the injured worker if they can. And we believe, I'm sure all of you believe, an injured worker is entitled to everything they should have under the statute, but no more. And so these are ways that we can show we can reduce costs. Sometimes sometimes we can get a case dismissed, but generally we put more emphasis on reducing costs. So we start with the concept of the power of the court to do something. And jurisdiction is the legal word for that. That's the power of the commission. And you may not know that we have concurrent jurisdiction in this country, and Mississippi recognizes that, meaning if you have somebody who can claim workers' comp in 2 different states, they can file in both states. So if you have somebody who's working in Oxford, Mississippi, and the plant's in Oxford, Mississippi, and the claimant's in Oxford, Mississippi, they could file their comp claim there. But if they got in a car wreck in Tennessee, driving the company truck, they can file it in Tennessee. And they can go to court in one or the other. But the thing to know to reduce exposure is they can't get double money. So if they go to Mississippi and get an award for $20,000, and then they go to Tennessee and do it again, that $20,000 will be a credit. So they won't be able to get more. Now, the part about the state and federal government, there's also jurisdiction between cases sometimes between the state of Mississippi and somebody who files a federal claim. But the unique thing that differentiates us from other states there is we have a statute that says maritime claims are not allowed. Mississippi's not going to recognize a maritime claim. Maritime claims a lot on the coast. We have maritime claims for workers' comp under the Longshore and Harbor Workers Act. The shipyard obviously is under that act. So all the people in the shipyard that work there under the Longshore Act, they're not under the state act, but you'll find lawyers that file in both state and federal, seeing which one they can get the most money from. But in Mississippi, if they file in Longshore, we can get that case dismissed in the state case under the rule. So it's something to know. Jurisdiction, the power of the court, our statute does not apply to any company that only has 4 employees. So 5 or more, statute applies, and if you don't have workers' comp insurance for the 5 or more, that's a crime. It's a misdemeanor, and they can have you, I don't know if they have you arrested, but they can certainly get a fine for not having comp, and it can hurt you in other ways as well. But if you have 4 or less, then you're not required to have comp. And I've run across quite a few companies, because comp's not that, it's expensive, that have made a point not to have workers' comp. That exposes them to tort liability. They can get sued and have a jury trial, but still they don't have to. Now, the owner's exemption is important, because I've had clients that knew about it saying that the owner does not count as an employee. But the catch is the owner's got to file a petition with the commission and get permission, get the exemption granted. It's not an automatic thing, but if they do, then the owner could be working, and he wouldn't count as one of the 4. Apportionment, long word, long screen, but apportionment is the notion that once a claimant reaches maximum medical improvement, you can reduce their award for permanent disability by the amount you can attribute to a pre-existing condition. So if you have a man who's worked and he hurt his knee, and the doctor gave him a 30%, and he comes back to work and he hurts his knee again, and now this doctor gave him 60%, you have to have medical support, you have to have documentation, but you can reduce that 60% by the 30 that he had from a pre-existing condition. And so we always look for that when claimants reach MMI. Did they have prior injuries? It has to be disabling, and we're able to reduce that award. Statute of limitations should be so simple, but in Mississippi, it's not that simple. It's more complicated. The statute of limitations, the basic statute is simple. 2 years. Get hurt on the job. If you don't file your petition to controvert within 2 years, then the claim's barred. Isn't that simple? Should be. We have a rule that is been attacked by a lot of the legal authorities, that if you have a claimant who has a work claim, a compensable claim, he receives his or her medical benefits, does not file a petition at before 2 years, you can close his file. You can deny future benefits. That's been criticized by some of the authorities, because a claimant sometimes has no idea there's a statute. The adjuster knows there's a statute. The adjuster has no obligation to advise the worker that the 2 year is going to run, and at the end of the 2 years, you can stop that. And there's been some attacks to it, but that is still Mississippi law that you need to be aware of. There's an exception under the 2 year statute, though, for minors. They get 2 years from the date of the age of majority, whatever that might be. Usually it should be 21 in Mississippi. There's some exceptions to that. And someone with a mental disability, their 2 years doesn't start until they're declared that they don't have a mental disability. So sometimes the 2 years will never expire with certain people. Then we get to the complicated part. 2 year statute's pretty clear. We have a 1 year statute of limitations. The 1 year statute of limitations is a situation where the claimant receives indemnity or compensation. So they get hurt and they get their comp. If the employer and carrier can file a form, it's called a B31 form, final report and release. Once they file that, and they have to properly serve it on the claimant's got to have something where they sign for it. It used to be just certified mail, but now Federal Express or something where they sign so they know they've received it. If they don't go back to the doctor in 1 year from the time that they receive the B31, the 1 year statute will bar the claim. And that's done pretty often in workers' comp, where we'll file the B31 to close the file. If nothing's happened, claimant hadn't been back to the doctor. So it's an effective way to close a file. Now, if they go back to the doctor within the year, then it stops the 1 year from running, tolls the statute, and to get it started again, the 1 year you have to file the B31 again. It's complicated on enforcing that B31, but it's certainly an effective way to close a file. We have a statute that says that if you don't report your claim within 30 days, it's barred. However, in all the history of the statute since 1942, there's never been a case that's closed a case on the 30-day. Now, let me give you, I have a case going right now thing that knows, but I'm going to talk about it in a second. I think I've got an angle. I mean, I have a person who didn't report the claim, finally reported it 3 months later. And so we went back to look and we found first that if she had reported the claim, we would automatically give her a drug test. We are prejudiced because we didn't have a chance to drug test. You like that? More, I've got a surveillance camera, scene of the accident, that would really have cleared everything up. It's a long story, but there's debate on what happened and all this kind of thing that would have cleared it all up with the surveillance camera. But the surveillance camera's got a tape, you know, that it runs and it disappears after 12 to 16 days. And so I don't have that anymore. So I think I'm arguing it to the judge. It's a novel question, hadn't been decided, but I'm arguing that we should be able to dismiss the case because this person chose not to properly report the claim. And now we can't use our surveillance and we can't use the drug test. We got all employers and carriers here, so everybody likes that. But remember, the claim can be reopened in certain situations. Now, here's more complications with the statute. The wages in lieu rule. So wages in lieu means being paid instead of compensation. In the simple example that I understand the point, I have employers, we've had employers who claimant reports the injury to the employer. The employer doesn't want to report it to workers' comp because, you know, lost time claims count. They cost you a lot of money. With contracts, construction people, it's a really big deal. And so they don't report it and they just pay the claimant their pay. They're at home. They're not working, but they get paid their pay. Well, is that a medical only claim? So the 2-year statute, or does it count that you have to file a B31? And the law is on the wages in lieu that you're going to have to file the B31, even though the carrier didn't pay workers' comp per se, paying them wages from the employer is the same thing. And there's some other more complicated examples I'm not going to talk about. Latent injuries also, this applies to most of the law. Latent injury, if there's a latent injury, the claimant's got an obligation to report it and file it when they knew or should have known. So there's one case where the claimant knew they were injured, didn't file anything because they didn't think they were that hurt. And then later on, after the 2 years, they had an MRI. And our MRI showed a little problem. And they were claiming, well, I didn't know I had a big problem. I just knew I had a little problem. Court found that didn't count. Statute barred that claim. They knew they had an injury and they should have reported it. But another person, and this is big on the coast, they had asbestosis. Now, asbestosis is a medical condition that doesn't manifest for 15 or 20 years. They literally, that fiber's in your lungs, but they don't know it's there. And so the law is, but those cases, is that statute doesn't run until a doctor tells them you've got asbestosis and you got it from work. So that makes sense too. Also, there's a case that talks about if you don't properly file your B3 and some other issues that might toll the statute. The B3 is the first report of injury. I encourage every employer who's listening to me to prepare your B3, file your B3 when you have your report, the first report. And if it's a no lost time claim, the rule is you're supposed to prepare the B3 and not file it. And I encourage you to do that as well to protect you against this exposure on statute. All right, I'm changing subjects. Independent contractors. We all know what independent contractor is. They're going to get a 1099 instead of a W-2, right? An independent contractor, what that is, there's so much law on challenging the difference between an employee and an independent contractor. I've done a whole 45-minute speech on that. But the bottom line is that if they're an employee, then it's workers' comp. And if they're an independent contractor, they're not. And remember, though, that a document, a contract that says on the top, independent contractor, this person is an independent contractor, we don't have any control, can be worthless. No value. They're going to look to the facts of the case, not what you signed in a contract. And so you got to look and see whether or not there's enough control by one side to control the employee or the independent contractor. If they have enough control, they're not independent contractors anymore. They're going to be entitled to workers' comp. Primarily in the construction industry, we have this rule about the statutory employee. And many of you know this, may not. So in construction, you're going to have an owner, general contractor, a subcontractor. In Mississippi, they recognize the sub of the subcontractor. And of course, the contractor, the sub, and the sub of the sub are all supposed to have workers' comp. And what I have seen in the contractor world is when the contract is bid and awarded, they all put up their certificates and they prove they all have comp insurance. But a year of the contract goes by, or 2 years of the contract goes by, and the sub of the sub doesn't have any comp insurance, and his employee gets hurt. So the law is that if the sub of the sub doesn't have comp insurance, the sub's comp insurance is responsible. If the sub of the sub and the sub don't have it, the general contractor's comp insurance is responsible. The owner is not responsible unless, I had a case, the owner did his own contracting on part of the contract. Well, that made him the equivalent of a contractor. Dual employment loan servant, you see that with the temporary leasing companies a lot, because who do you actually work for, right? You sign up with Kelly or one of those companies, and then they place you someplace, and really you become, for all practice intents and purposes, you become the employee for all of the actual person that you're being leased to. And so the law makes both of them employers, dual employment, and both of them can ultimately be held liable. You can also litigate that, especially with the loan servant idea. I have cases where the one employer allowed an employee to go work for another employer, and that's where the injury occurred. And generally, the one who they were working for or doing the work for, they weren't their employee, they weren't their W-2 employee, but the one they're doing the work for when they got injured is going to be the comp that's responsible. I found in the leasing companies, that's usually covered with a contract. Somebody's responsible for who's going to have the workers' comp. Independent intervening cause. I can read it. Every natural consequence that flows as a direct and natural result of the injury arises out of the injury and is compensable. But if the independent intervening agency interrupts the chain at any point, liability of the carrier stops. All that means you have a guy working in his truck. He's driving his truck on the clock with a company-owned vehicle, and somebody rear ends him. He gets hurt. Hurts his back, certain spots. All right, gets better. Now he is still under doctor's care, and he's driving the truck again. He gets another wreck, same spot, rear-ended, hurts his back again. That second injury becomes an independent intervening cause of the first injury. So the first injury can be dismissed because you're now going to be dealing with the second injury, and that's a defense that you look for. Quasi-scope of employment is one. It says that if you get injured doing something you would not have done but for the injury, then comp's going to have to pay. And my example there is physical therapy. You get hurt on the job, you have to go to physical therapy. Sometimes people get injured in physical therapy, and that would be a continuation of the comp case. You couldn't claim independent intervening cause there because it's still part of that same work injury. That make sense? Yeah. Fraudulent inducement, I want to spend 2 seconds on. This is a defense that the courts have not yet recognized, and with the ADA, it's really not going to come up much. But the concept of fraudulent inducement is the claimant comes and he's hired and he's interviewed for the job. And this would be after he got his conditional offer of employment under ADA. And he says, I've never hurt my back. And then a little later on, he injures his back. And we find out that he had 2 back surgeries, and we never did test for that. And so he's lied to his employer. You can argue that the injury we have should not be compensable based upon his fraudulent conduct. I've had one, but I never was able to win it. Deviation. This is where you're working and you deviate from your job. And y'all have been to this seminar before. I'm going to tell the same story again. It's a case about a milkman. And the milkman in those days was delivering milk, and he delivers milk to this house, and the lady's there, and he goes in, he delivers the milk, and then he and the lady kind of know each other, so they go back in the bedroom. Husband comes home, finds out the milkman's in there, and shoots him. Milkman files a workers' comp claim. The court found that he was deviating a little too much. And so they deny that claim. And the deviation, if they are in the course of their employment, then it's not deviation if you can show that it's reasonably incident to the employment. And the case there is we had a driver driving in the company truck and stopped to help somebody, a good Samaritan type of thing, to help them change the tire. And he stepped back into the road and got run over. And so he filed a comp claim. Well, employer and carrier argued he was deviating. He wasn't supposed to be doing that. And the court found that was not a deviation, that it was connected enough to his work for it to be compensable. Now, here's another rule, simple rule, ought to be simple. And the courts have just had fun with it, as far as I can tell. Going and coming rule is so simple. If you're on the clock, you should get your money. If you're off the clock, it's not compensable. If you're driving to work, you don't get covered until you punch in. And when you punch out, you don't get covered going home. Doesn't that sound simple? Yes, it does. Now watch this. These are the exceptions. If you are a traveling employee, then you're covered. So if you're a traveling salesperson, that's part of your job, that you're on you drive, then it's going to be a covered claim. That takes a lot of people out. If the employer furnishes, this makes more sense. If the employer is furnishing the truck or paying you mileage, then you're covered. I don't like this one, if you get injured in the parking lot, and there's a case where it wasn't even the employer's parking lot, it was another parking lot. But if you get injured in a parking lot before you go to work, the concept is that extends the workers' comp to cover you. So parking lot claims are going to be covered. And most of them are, robberies and those kind of things, injuries in parking lots. If you're doing personal comfort in brushing your teeth, going to the bathroom, those kind of things, you're going to be covered. If you have a hazard on a single route to work, and that's a case from here, I'm from Pascagoula. Ingalls they got almost the interstate highway that runs from Highway 90 to the yard. I mean, it's a 4-lane road, concrete road, and this guy was driving on that. And in that particular case, there's a big sign said hazard, and he hit the sign and got hurt. And so they said, because the only way he could get to work was driving on that highway, the Ingalls Highway from 90 to the yard, that made it compensable. And there's more of those, and I won't just take my word for it. If you have a going and coming case, you need to study it to see if there's an exception. Third-party claims. The third-party case, once again, the example best is the car wreck case. The guy's driving down the road. He gets hurt. He's on the clock. Man rear ends him. And so he gets his workers' comp, but he's got a suit against the man who hit him. The man who hit him was negligent. He was at fault, and they can sue him in a jury case, and he can get more money because he's entitled to pain and suffering money in a workers' third-party case. We don't pay any pain and suffering in a workers' comp case. And so when that happens in that third-party case, if there's a settlement or if there's a judgment from the jury, the statute provides how that money gets divided. First, the claimant's attorney gets paid. The plaintiff's attorney gets their fees. Sometimes they charge, a third or 40%. Then the employer and carrier gets reimbursed for its lien. And only after that does the claimant get any money. And there are situations where the claimant doesn't get any money because they've already gotten all their comp was so high, they weren't able to get any more from the settlement that they had. I've got several cases where they got the 25,000 policy limits. So that's all there was. There's a rule called the made whole doctrine that applies not to workers' comp, but to other cases. There's cases with Blue Cross Blue Shield that the claimant will get made whole first before the Blue Shield gets paid. But our law in Mississippi, because it's statutory, and there's other cases for statutory liens, we get paid second before the claimant gets paid. I want you to be aware of a new United States Supreme Court case, Gallardo, Garllardi, I believe, U.S. Supreme Court case. You can Google it. United States Supreme Court almost never has workers' comp cases. But in this one, they had a Medicaid lien case. And there was a real debate in the country about whether or not Medicaid could assert their lien, as does Medicare. We're real familiar with Medicare asserting liens. The United States Supreme Court said yes. So we're all going to see Medicaid, which is administered by the states, not straight federal. We're going to see Medicaid in cases like this. If that truck driver, the guy who got rear-ended, was getting Medicaid, if Medicaid paid any of those bills for his car wreck, they're going to want to be reimbursed. And so whether they get reimbursed before and after us, it's not too clear, but I would say it's concurrent. But either way, you're going to see Medicaid be more aggressive because of that. Intoxication, illegal drugs, improper prescriptions. The law changed in 2012 in Mississippi, and this is one area where it really did make an impact. So now, under the law, if an employee gets tested and gets a positive test for an illegal drug, if he gets a positive test for a drug that he has, but it's contrary to his prescription's use, so he's supposed to take 1 pill a day, and the blood test showed that he's taken 20 pills that day, then that would be a violation of this rule. If he's tested positive marijuana as a medical cannabis patient, if he gets a 0.08 blood alcohol, which is the DUI number, Mississippi, and this is where I've seen this the most, he refuses the test. He won't take the test. In all of those circumstances, the law now there's a presumption that he was intoxicated, he or she was intoxicated, that was the cause of the accident, and if that's the case, the claim can be totally denied. And I've seen these, and we're getting them denied. I mean, he's got a right, the claimant's got a right it's a presumption to prove otherwise, but it's pretty hard to prove the positive test is bad. It can be done. I had a case with poppy seeds that claimant prevailed. He proved that he'd eaten poppy seeds on one that morning, and that kicked the positive test. But most of the time, we can now prevail on those cases when we didn't before. Now, willful intent to injure is kind of a combination of different things. The first one, if an injured worker commits suicide, intentional act, it's not compensable. If he tries to commit suicide and gets hurt doing it, it's not compensable. Change subjects. If an employee is injured by a third party, either intentionally or accidentally, but it's for a non-work related reason, it's not compensable. It's a personal piece. And I had a case, these two guys that had a big, some kind of gambling thing going on, and one of them owed the other money. And so they both were employees. And so my man, the claimant, not my man, the claimant sitting in the truck, and he owed the other guy money. The guy comes up and owes him money. Where's my money? Oh, I don't have it today. And he popped him shot him. And that person filed a workers' comp claim. He claimed he was on the job, he was working in the company truck, and this guy shot him and he should get comp. He did not get comp because it was a personal reason. It had nothing to do with work. It was not because of employment. And this is the best case I know why I encourage employers and carriers, when you have an injury, you need to conduct a good investigation. The employer should do an investigation. You should call your insurance adjuster too, and they'll assist you and they'll help. Sometimes they'll take over your investigation, but don't just write it down. Go a little farther, because if they had not done that here, they may not even have known about the personal reasons, would they? They wouldn't know the story. They just know he got shot. It's important. Zone of special danger. That's just an added little twist to the same idea that if those are cases where there's a situation where the place is working in a place where is dangerous all of the time. So the reasons aren't as important. And the examples, a taxi cab driver in downtown Jackson, Mississippi right now, they take their life in their hands. And if they get shot there, that's going to be compensable. The imported danger doctrine is one where, so the example is, claimant comes to work with firecrackers. lights him up, and his buddy's standing next to him. Firecrackers don't do right, and they blow up, and both of them are injured. Does the guy who, the bystander who gets hurt, does he get comp? Raise your hand. Does the guy who brought the firecracker to work get comp? Yes? No? Raise your hand. The answer is no. No, he doesn't get any comp. Acts of God, the law generally is that if it's an act of God, that it's not compensable. However, I will share with you under the cases, there's lots of cases where the guy's in the parking lot and lightning strikes them, and they find that although God did send the lightning, he was still at work standing there, and most of those have been found compensable. Hadn't found a way to challenge that one. Average weekly wage is a way to reduce exposure. Every state has their own rules about average weekly wage. Ours is you have to determine the 52-week pay period prior to the date of injury. Some states have 12 weeks, 15 weeks, 30 weeks. We have 52 weeks. So if you have an employee who's worked 52 weeks, you find their 52 weeks prior to the date of injury. You divide it by any of the weeks where they worked. So if they were not working, you don't count that. Sometimes we divide that by 48 or 47. And whatever that is, that's the average weekly wage that you use to pay comp. They're going to get 2/3 of that average weekly wage, as Tristan said, subject to the cap. But if you have an employee who's worked less, 6 weeks or 8 weeks, then you look at that to determine if that division of that 6 or 8 weeks is just and fair. And so that would be to both sides. If it's a high average weekly wage, of course, the claimant was going to keep it. And if it's low, then they'll say it's not just and fair. And same for the employer and carrier. If it's not just and fair, then you go to the third category, which is a similarly situated worker. And so what you do there is you find your employer to see if they can generate a wage statement of a co-employee, similarly situated worker for the 52-week pay period prior to the date of injury. And if so, then you'll argue to the judge that's what you should use. I like to get 3, not required, and then you average out the 3 to just try to show that you're trying to be just and fair on establishing your average weekly wage. It's really important not to use 8 hours times 4, the hourly rate times 40 for an average weekly wage, because most of the time that's just not accurate, and you'll see that happen sometimes. Now, Tristan touched on EMEs and IMEs earlier. In a litigated case, if the employer and carrier does not agree with the treating physician's opinions, the employer and carrier has very few rights in workers' comp, but they have a right to require the claimant to attend a second opinion with a doctor chosen by the employer and carrier. That's an EME. And then whatever that doctor says can be the basis of your case. Then if the claimant's attorney doesn't like it, then you can ask the judge to appoint an IME, independent medical evaluation. We employers and carriers can talk to our EME doctor all day long. They're like an expert for our side. When you get an IME judge, though, an independent medical evaluation, the judge appoints the IME doctor, and you cannot talk to the IME doctor at all. A new case came out, I think 2 or 3 weeks ago, where the employer and carrier saw a typo or an error in the letter of the IME doctor. So he calls the nurse and brings that to the nurse's attention. That's what he said. Well, the IME doctor then issued an addendum and changed his report that favored the employer and carrier. So it looked kind of bad. And so they fined the lawyer $1,000 and they struck the addendum letter. So it was really something you don't want to do because of penalties with IME doctors. Vocational rehab. Now, Tristan talked about the statutory maintenance, but this is an expert, a consultant, and we use vocational rehab consultants a lot in workers' comp. Once a claimant reaches maximum medical improvement, the doctors are going to provide not only the anatomical rating that Tristan was talking about, but restrictions. Many, sedentary, medium duty, heavy duty. Some of them are a lot more specific about no lifting over 10 pounds, 15 pounds. You see that a lot. And so when you do that, the question is, what is the claimant, if it's a scheduled injury, body parts, it's industrial loss of use, that's the word we use. If it's an unscheduled injury, what the words we use is permanent loss of wage earning capacity, which, that makes it a little more understandable. And that's what can the claimant do? What is their ability to work now that they've had this injury, and then they're going to be entitled to money for their permanent loss of wage earning capacity. And so the way you prove that or don't prove it is we hire a voc expert. And the voc expert then will do, that's what they do. They'll go out, they interview the claimant or get information, and then they'll do surveys of jobs that are available. I really encourage always to use voc experts that are local, know the local economy, know the local employers that can get jobs from them, not just go online and come up with an answer online. And so you want to try to get real jobs, not hypothetical jobs, to actually prove what you're doing. There's a new wave in the workers' comp world with voc, where they're using statistical evidence based upon surveys, local and statewide. I don't think they're as reliable, but we're seeing more of that. And so it's a litigated area right now, debating on exactly what the value is of a permanent loss of wage earning capacity. And those of you, if you have insurance, you turn your case over to the adjusters. So some of these things for the employer piece, you'll share information with the adjuster, but they'll be the lead. You'll be the follower once you have the case, once it's in litigation, or once the adjuster take over the file. Surveillance is something that I really advocate. However, surveillance is very expensive. And so we try to use it wisely. I like to have the surveillance tied into something like going to a doctor's office, so there's not a question about who it is, and so we know we're following somebody. I have settled a lot of cases with surveillance because claimants get bored. They're sitting at the house. They testify they can't do anything. They tend to want to exaggerate their injuries, and then we'll get film of them running the tractor, picking up loading trucks, and all kinds of things taking place. I had one, they went horseback. They rode a horse in the barrel races when the lady testified under oath that she couldn't get out of a car, let alone ride a horse. And so you settle those for a pretty good small amount of money when it happens. There is such a thing in Mississippi as a second injury fund, but it's not very often used. It's only for scheduled injuries. And the idea is that if you have one body part that's lost, 100% lost, and now you have a second body part, the other side. So a left eye and right eye, the second injury fund will pay for the second eye, so you'll get more money out of the second injury fund. That's all I have. We got any questions? We're moving through really fast. All of this can be, the book that you can download has all of this in so much greater detail. We're really just kind of hitting the highlights. You're cold? Is everybody cold? Several. Just touch it, just a little. All right, well, Myra Cunningham's going to talk about bad faith.
Good morning. Again, my name is Myra Cunningham. Oh, you're going to put this down. I'm a lot shorter than them. That worked. My name is Myra Cunningham. I'm coming up on my first full year with the firm, and this is my first seminar hazing experience. So I just wanted to thank y'all all again for being here today. So, and I'm going to get used to using this clicker. Let's see. My job here today with this little presentation is to scare you all about bad faith claims. So, before going into it, first and foremost, bad faith claims are exceptions to the workers' comp exclusivity rule. And that may sound foreign, so let's do a little refresher on that. In Mississippi, workers' comp laws replace traditional negligence actions for a no-fault system of payment. Essentially, the exclusive liability of an employer to pay compensation is the product of the bargain that is the Mississippi Workers' Comp Act. Employees gain the benefit of compensation for all work-related injuries without reference to the fault of either the employer or the employee. Their consideration in exchange is surrendering the right to pursue all other areas of liability. Employers gain the benefit of having the amount they have to pay any worker capped, and their consideration in exchange is agreeing to assume the financial burden of all work-related injuries without reference to fault. And this is, again, a refresher, so it's not in the slides. This is me just explaining this rule. But that sounds good, right? Benefit bargain of the act. With bad faith claims, all of that goes out the window. A bad faith claim is an independent tort and can be filed against the employer, carrier, and or third-party claims adjusters. There have even been cases in which individual adjusters themselves have been found liable for bad faith claims.
Sorry, it's just right.
Oh.
Better. Sorry, y'all. We just want to make sure Myra's looking good on camera.
Sure, they'd rather see her than me.
All right. So again, these claims are dangerous for two big reasons. They're not tried before the commission and instead can be tried by a jury in either state or federal court. Thus, you're at the mercy of 12 peers rather than an administrative law judge or the commission itself that has extensive experience in the workers' comp arena. Second, these damages are not capped as in typical workers' comp cases. Bad faith can expose employers, insurers, and third-party claims adjusters to punitive damages many times larger than the employee's actual damages, aka you could be subject to paying a lot more money in damages. So a few other things. Claimants cannot initiate actions for bad faith until the underlying workers' comp claim for benefits is final, and the claim must be filed within 3 years of the final disposition of the workers' comp claim. So now let's talk about the elements of a bad faith claim. A claimant must first show that a contract of workers' comp insurance existed between the defendant and the plaintiff's employer, and that's easy enough. And second, a claimant must show that the carrier denied the plaintiff's compensable workers' comp claim without legitimate or arguable reason. So let's piece down that language a little bit. The Fifth Circuit has interpreted an arguable reason to mean a reason sufficiently supported by credible evidence as to lead a reasonable employer to deny the claim. Decisions that are made in good faith, but ultimately determined to be wrong, generally don't constitute bad faith claims or warrant punitive damages. Both federal and state courts have held that the opinion of a treating physician that no disability exists constitutes an arguable reason for denying benefits. On the other hand, if an in-house medical expert opines that no disability exists without sufficient information, there is no arguable reason for denying benefits. So while registered nurses and in-house vocational experts can play a valuable role in evaluating claims, their opinions should never be used as the sole basis for denying benefits. Okay. Let's go over some examples. While bad faith claims, and third, forgot the last factor, the claimant must show that the denial of benefits constitutes a willful and intentional or malicious wrong. So again, let's go over some examples of bad faith claims. So while these cases are determined on a case-by-case basis, we can look at some prior Mississippi case law to show us what not to do to be found liable for a bad faith claim. First, you should never terminate benefits simply because the claimant reached MMI or skipped a doctor's appointment. Always ensure that your claims adjuster makes adequate initial investigations, that the claim continues to be investigated throughout its pendency. You should never withhold benefits or try to force a claimant to settle. Trust the guidance of the treating physician's impairment rating at MMI and pay accordingly, and don't delay your investigation after the claimant reports errors. So again, these rules often come from cases in which juries found that the employers or carriers were liable of acting in bad faith. So now let me give you a little more positive case study with a 2019 case out of the Mississippi Court of Appeals. In Liberty Insurance Corporation versus Tudor, and again, this is just not on the slides, gonna just read it out to you. A UPS delivery driver, Lee, was carrying a box up some stairs to make a delivery when a dog jumped out and startled him. It caused him to twist and injure his back. So he immediately called his manager and reported the injury. She advised him that she would send another employee along to help him finish his route and to call him as soon as he got back to the UPS facility. So he returned to the UPS facility that evening, called his manager, again recounted what happened. And during that conversation, Lee told his manager that he did have a prior back injury that he received chiropractic treatment for prior to this dog-related incident. So that manager heard this and later testified that upon hearing this, she just assumed that this injury was not work-related, or it must have been from that prior injury mentioned, so she never reported this claim. 6 months later, and after extensive medical treatment, Lee filed a petition to controvert with the Mississippi Workers' Comp Commission. The petition didn't contain any of his medical records, but it did list the name and addresses of some of his physicians. It didn't list any witnesses. It was pretty bare bones. So because of this lack of information, and because this was the insurer's first time hearing of this injury, they initially denied his injury and had counsel serve him with his first set of interrogatories and a request for production of documents. So after further investigation and through the usual discovery process, the insurer received medical records from his providers, they deposed Lee, and they had an employer's medical evaluation performed on him. So through all this evidence gathering investigation, the insurer ultimately amended its answer to the petition to controvert and admitted the injury was work-related and paid comp benefits. However, after this comp claim was settled, Lee filed suit against the employer and the insurer alleging bad faith handling of his claim. A Mississippi jury found in Lee's favor and awarded extra contractual damages of $500,000 against the employer and $100,000 against the insurer. Lee's employer settled, but good for them, the insurer appealed. Unfortunately for that insurer, the Court of Appeals concluded that they did have an arguable good faith basis for initially denying that claim. The insurer promptly investigated the claim by availing itself of the discovery procedures, doing that EME and all those other steps. And they did all this before they admitted their compensability. Therefore, those extra contractual damages were not warranted. And here, this is an example of a prompt and thorough investigation, saving this carrier from $100,000 in bad faith damages. So I am forgetting the clicker. So a few more suggestions to avoid being liable for a bad faith claim. Always encourage prompt reporting of injuries. Act as quickly as possible and avoid unexplained delays. Lack of communication and delays lead to unhappy claimants, and unhappy claimants are more likely to pursue further remedies. Thoroughly and promptly investigate each claim. A thorough investigation involves obtaining all available medical information relevant to the claim and interviewing employees and individuals who have knowledge relevant to the claim. There's no rule of thumb as to how long the investigation can take before the delay in payment becomes unreasonable, but courts have held that a 1-month delay due to oversight was just merely negligent and it didn't arise to the level of bad faith. Similarly, a 6-week delay was not found to be in bad faith, but what's important here is that the carrier is actively investigating the claim. An employer or carrier has an obligation to continue this investigation as long as that claim exists. However, if the investigation is not completed within 14 days, you should consider filing a B-52 form or a notice of controversion as a safeguard. Denials should only be made, again, where there is a legitimate and arguable basis for doing so. So make sure that all those reasons are well documented. And this is an important one. Act objectively and professionally and assume that your claims file will be discoverable in litigation. Don't record disparaging comments or observations. Keep your notes professional, accurate, and unbiased. It's important to remain open-minded and objective when analyzing individual claims. Don't just follow bright line rules and assume that the claim fits a specific framework. Instead, pay careful attention to the specific facts of each claim because the usual outcome might not always be the correct course of action. Once the petition to controvert is filed, be cautious, as Tristan touched on earlier, with your communications with medical providers so as to avoid any ex parte communications. And finally, prior to denying any claim, you should seek advice of counsel. While it's not absolute, advice of counsel is an affirmative defense that can beat a bad faith claim. And that is all I have for you today. Thank you all for your time. I believe we're about to have a little 15-minute break.
Make it 10.
10? Okay.
10
All
minute
right.
break.
Thank you all.
Association. They didn't hear me? Do it again? Do it again. I'm gonna do it again. They couldn't hear me, but didn't have the mic on. So I want to thank the Gulf Coast Human Resource Association again for their partnership in putting on this piece of the employment law seminar. I want to recognize and introduce Julie Wade, who's the HR business partner with the Island View Casino in Gulfport. And more importantly, she's the president of the Gulf Coast Human Resource Association. She's going to say a few words about the association.
Thank you so much, and I'm so glad to be here. Good morning, everyone. If you're not familiar with Gulf Coast Human Resources Association, I'm here to tell you all about it. It is an affiliate of SHRM, which is the largest HR association in the world. We're the only HR association along the Mississippi Gulf Coast with a wide variety of members in all types of organizations. It doesn't matter if you're new to HR or have years of experience, our members are provided with resources through SHRM, monthly meetings, networking opportunities, and support from Mississippi Gulf Coast HR professionals. In order to be a member, you do have to be a SHRM member as well. If you have any questions, you can send us an email at gulfcoasthra@gmail.com. By the way, we're not your average uptight group of HR folks. Our group is very down to earth and welcomes any and everyone who joins. If you're looking for an opportunity to get PDCs, meet great people, and grow professionally, this is the HR group for you. If you're interested in joining or attending any of our upcoming events, the website is listed on this PowerPoint, but it's also gulfcoast.shrm.org. Each month we have a chapter meeting worth 1 PDC if you have your SHRM certification. Our upcoming chapter meeting in June will be on June 8th from 7:30 a.m. to 9:15 a.m. at the People's Bank on Howard Avenue in Biloxi, Mississippi. There is an Eventbrite link which can be found on our website, gulfcoast.shrm.org. Dr. Jared Burns will be speaking on the topic HR Professionals, the Next Generation. Next, we have a very exciting event upcoming on June 16th. Table Talks, All Things HR. It's from 8 a.m. to 1:30 p.m. at MGCCC in Gulfport. We have 7 amazing facilitators: Dr. John Kelly, Diversity, Equity, and Inclusion; Stacy Resser, Organization and Employee Development; Stephanie Schaaf, Benefits; Tiffany Stokely, Technology; Susan Desmond, Legal and Compliance; Summer Mason, Talent Acquisition; and Cynthia Render-Leach with Mental Health. What makes it worth attending? Attendees have the opportunity to sit with an expert along with 5 to 6 other peers, ask questions, discuss best practices, and brainstorm. This is a limited seating event and we will sell out. So those who are SHRM certified will be presented with 3.5 PDCs for attending. Tickets are only $40, which includes breakfast and lunch and the opportunity to learn and network. The link to register is on our homepage of our website, gulfcoast.shrm.org. And last but not least, the Mississippi State SHRM Conference will be held at the IP Casino Resort again this year in Biloxi on September 27th through the 25th through the 27th. We do have a big announcement, so please stay tuned. If you don't follow us on any of our social medias, we do have a LinkedIn and a Facebook where you can keep up with any of our posts and events that we have. And I thoroughly thank you all for listening. Please join. If you have any questions, please feel free to email me, or you can email us at our association email address. Thank you and have a great day.
I'll leave it off. All right, we're going to go back now and start this part of the seminar. Can take my face off there. Bottom. All right, workplace violence training for supervisors is our seminar piece now. As you can see from the picture, that's not a very good work environment, is it? Well, I'm going to be talking about something even more serious than that. You want to touch something? It won't work. Yeah, you would. There we go. I think I read it. So I'm going to read this and y'all can read along with me. Primary focus of this training is to help supervisors be more aware of warning signs and potential violent situations, steps you can take to keep yourself and others out of harm's way. But if there's a situation that cannot be stopped, you need to be aware of your employer's emergency response procedures that you can assist employees. Workplace violence is one of the major causes of death in the corporate world, second only to transportation. So second only to car wrecks and things like that. Every year, millions of American workers report having been victims of workplace violence. 23% of employees throughout the world report experiencing violence or harassment at work. Over 2.6 million Americans were victims of non-fatal, where someone didn't die, workplace injuries in 2021. 481 workplace homicides in 2021, 387 intentional shootings resulting in death in 21. And you can see the graph. You can't really see it that well, but a large percentage of the people involved are under the age of 24. One of the major horrendous workplace violence incidents occurred over 30 years ago. 1986 Edmond Post Office massacre occurred, third largest mass murder committed by one of the individuals in a single accident. Patrick Sherrill, a postal worker, reported to work on August 10, 1986 after receiving a formal reprimand the day before. He was armed with 3 semi-automatic pistols and ammunition. By the end of the day, he had 14 postal workers. He killed 14 postal workers and wounded 6 more. This instance of workplace violence is coined and commonly called going postal. I've never heard that before, but I've heard a whole going postal many times before. That's where the story comes from. The following are examples of 3 incidents that happened in America in the last 2 years, involved the death of 21 victims. We're going to talk about the people. Now, in California, they won't allow you to say the name. Remain anonymous for good reason. Persons sometimes wish to be known, and we don't want them known. He was fired. He stayed at home. That's not right. On June 25, 2019, he worked for the parts department in Morgan Hill, California at a Ford dealership. He was fired. He walked to his car, the parking lot, got his gun out and returned and shot and killed his service and parts director, his supervisors, the parts manager, one other employee. The investigation said he was disgruntled. And I drilled down a little more and learned he was 60 years old. Co-worker described him as being a very quiet individual, just kind of minded his own business, kept to himself, and did his job. So people didn't really know that much about him. After being fired, he stayed at the dealership for a while. He was heard to say he didn't understand why he was fired. And I think for HR, that's important. He didn't understand why, and he later shot and killed himself. The next one is a guy named Samuel James Cassidy. maintenance worker for the Santa Clara Valley Transportation Authority in San Jose, California, made $160,000 a year. He had a good job. May 26 to 21, he set fire to his house. He came to work, shot and killed 9 co-workers, and then he killed himself. 57 years old. Shooting occurred in 2 separate buildings during the busiest time of the day. There were 100 people milling around at the time he was shooting. He targeted some people that he apparently knew, other people he didn't kill. Fired a total of 39 rounds from 3 semi-automatic handguns, which were legally obtained. He had been employed since 2014. His ex-wife said he had anger management issues after he became angry at his co-workers for what he believed was unfair work assignments. She said he talked about killing people for over 10 years. Had a pattern of insubordination. I think this is important. Pattern of insubordination and had gotten verbal altercations with coworkers on at least 4 separate occasions. He faced disciplinary action, but nothing was ever done. Nothing was done for discipline. In April of 21, he aired his grievances over the radio at work. He was angry over some kind of unused vacation pay. Andre Marcus Bing, November 22nd, 2022. He was a night shift manager at the Walmart Supercenter at Chesapeake, Virginia. Shot and killed the co-employees and injured 4 others before he killed himself. He killed 6 people, 31. Legally purchased a 9mm handgun that morning. No criminal record. Worked for 12 years. Had a good record. He was described, though, as difficult and known to be hostile to his coworkers. Survivor said he was laughing when he was shooting. Technical difficulty. Another said he seemed to target specific people, shot them multiple times even after he knew they were dead. He wrote a death note and said that he was mocked by his co-workers. His phone had been hacked. He wanted to make peace with God, and he was distressed that he didn't have a wife. I don't know what factored that in, but he obviously wasn't a very happy man, was he? That's not me. Can it be adjusted? Any way to make this a little less sensitive? I'm just touching it. Doing that. Believe me.
I'll just.
Believe me, I am taking my finger off of it and I hit it and it runs. So I'm hitting it too hard or something. Can you do it?
Yeah.
Can you do the screen?
Yes.
Good. Well, you do it. Just go to the next screen.
Oh.
Maybe not.
It's not me.
Just here, give me that.
Try that. Okay. I didn't do it. You think I did? No. Go ahead.
Nope. Okay, it's really not.
It's not me. That's,
I don't know what's going on. Okay. I'm sorry, y'all.
can't give up.
Tell my computer people that even if it's foolproof, it's still breaking.
Exactly. Thank you. Me too.
I think this is the next slide. Was it?
Huh?
Was this the next slide?
I have no idea.
No. I think
All right, that's where we were. Just one slide now.
click next.
Oh,
It must be the PowerPoint itself. Okay, well, I know the next.
I've done it at home a million times on a computer, so it's something.
Okay.
What
that-
source range is?
That's it.
Huh?
This
We're
is
there?
the slide, so just.
Okay.
Close of the session, you'll be able to explain what workplace violence is, tell how to recognize violence potential, cite techniques to diverse potential violent situations, describe how to respond effectively to workplace violence. Oh, yeah, every time. Just one.
It's gonna do it every time.
It can't. It just can't. Tristan, you have a suggestion?
You can take a quick break, I can pull with it, see if I can.
Yeah, let's take a short break. See if maybe Tristan can fix it. That'd be great. Thank you. Otherwise. All right, we're moving right along. We're back on the screens. Hopefully we can get to the next one after this. So it starts with many times we're going to start with a true definition of what is workplace violence. An assault or other violent act or threat that occurs in or related to the workplace and entails substantial risk of physical or emotional harm to individuals or damage. Sometimes you need to add in damage because you don't want, it's workplace violence if one of your employees is in his office and tears everything up and throws lamps and pounds chairs. That's violence too. Good. It can come from coworkers. It can come from external visitors or customers, from former employees, vendors, independent contractors, and family members. It's not just employees, although we're going to focus today on co-employee violence. It's not, though, annoying behavior. It's not disliking somebody, and it's not a rude customer. It's going to be a level above that when what we're talking about with workplace violence today. Okay. How do you recognize the violent potential? It can be very difficult to know when a person's going to be violent. While not all people show the following signs, these types of behaviors and physical signs can serve as warning signs a situation can turn violent. One warning sign may be a predictor of violence, may not be a particular violence, but numerous warning signs can be. And these are just checklists in your mind that you want to think about if you are faced with a situation we're talking about preventing later, but this is facing with a situation of somebody, a co-employee of yours, an employee of yours, or a contractor, or anybody on your premises that's gone berserk, gone crazy, hopefully not wielding a gun, but possibly wielding a gun or a weapon, or just being combative. Next one. So do they have a history of violence? This is probably one of the easier ones. Do they have a fascination with weapons, active violence, or both? Do they demonstrate violence towards inanimate objects? And have evidence of earlier violent behavior? I know many employers do background checks as part of an application process to consider whether you're going to employ somebody. And I think in today's times, with the prevalence of these type of mass shootings, it's certainly a good idea. I know some companies require it. The governmental companies all require the background check. But if you're not required to do it, it's certainly something to consider. When I hear fascination with weapons, what comes to my mind is the video games. There are, you got to put that in one factor by itself is nothing, but with factor other things. But video games are really violent these days. I think they like to see more blow-ups, more people, and some of the movies I like are really gory. Blood and guts and all those things. So that's a factor under this history of violence that's got to be considered. Threatening behavior. Is this person that you're looking at a potential person to go crazy? States the intention to hurt someone, holds grudges, demonstrates excessive behavior. Too many, not just make a phone call, but too many phone calls. Not just gift giving, but too many. An obsession, which is really more than all of those things. Do they seem preoccupied with violence? Next. Do they have intimidating behavior? Are they argumentative? Do they display unwarranted anger? Are they uncooperative or impulsive or easily frustrated? Do they challenge peers and authority? Now, argumentative, I'm a lawyer, so I think most lawyers I know would qualify as being argumentative, whether you like it or not. Challenging peers and authority figures, that happens sometimes. All of these have got to be taken in context. But if you have somebody who's in your employ that's really hothead, just people joke about, that's a hothead, it's something to be aware of, to be considered. Increase of personal stress, unreciprocated romantic obsession. And you got to get to know your employees before that would come about. That's something they would keep to themselves unless that you reach out. And your foreman on your jobs, they need to know their employees more than maybe they've done in the past because of this. Is that person having serious financial problems, or are they having serious family problems? Or obviously, and that's a theme you'll see, have they lost their job? Do they have negative personality characteristics? Suspicious of others, sense of entitlement, unable to take criticism. We all know people like this, don't we? They feel like they're the victim all the time. Now, the people that we know like that, these characteristics are not something that is just overwhelming most of the time. If you have someone that's really bad, then you probably are recognizing that. But this is a factor that you put on a checklist to consider. Are there marked changes in mood or behavior? They always been pretty easygoing, and now they're real short, yell at people. Do they talk irrational, about kind of unusual things? People think back, well, I wonder, what's he talking about? Do they appear depressed when they weren't depressed? Do they demonstrate noticeable decline in work performance? Now, that criteria is the only one so far that is truly objective. Because if you're the employer, most employers do a performance evaluation every year. If you don't do a performance evaluation every year, clearly, though, in the supervisory positions, job performance and how good and bad they do their job is something that's discussed freely, openly with employees, and it's objective. And so that's a big character. If you have somebody who's been doing great, their job performance has been excellent for a number of years, like some of the three I just mentioned, and all of a sudden you see this change, maybe you as an employer need to take some action. Are they socially isolated? Have a history of negative interpersonal relationships? Have few family or friends? do they, and I've known this to be true, maybe you do too, do they view your workplace as family? And you know, some employers use that as a theme. We treat you like family. Well, if you really treat them too much like family, that's probably, if they rely upon you for things they would rely upon families, check that box. Are they obsessive or involvement in their job? Too obsessive with their job. Potentially violent person may be demonstrating these characteristics. They speak loudly, frantically, or quickly. They gesture wisely. They use aggressive stances and gestures such as pointing, getting close to clenching their fists. They're making threats or personal insults. Now, hopefully some of these you wouldn't tolerate in your workplace. This is going to the extreme. But if you do tolerate them, think twice. We recognize now that I'm changing subjects on some violent situations can't be stopped. But you can use proven techniques to take steps to reduce a situation that's escalating. Now, we've changed subjects because now what the next group of slides is talking about is not assessing employees when everything's fine. That's the first set we went over. You go over their personalities, you look at your employees, and I think the takeaway here is, as I mentioned, employers need to know their employees better than many times they do. I know I chatted with somebody they know, and I was talking about this, and they said, you know, if you're an employee and you keep to yourself and introverted, people ought to leave you alone. You know, they don't have any business in inquiring. But that's not really right. If they're in the workplace, there may be needs for employers to know a little bit more about their employees. Now we've switched gears. Now we're talking about a fact situation that you've got an employee. Let's just go ahead and put the gun in their hand. You've got an employee that's lost it. And he is at a place now and he's wielding a gun. He hadn't shot anybody, but he's wielding a gun back and forth, talking about he's going to do something with this gun. And he goes on and on. What do we do? And I like this one. Don't just run over there and talk to him. Stop your life and think about what you're about to do. Assess your situation. You have to appear calm. If you're not calm, he or she's not going to be calm. If you're not calm, co-employees aren't going to be calm. You have to be patient. Empathetic. Empathetic means that you have to try to think about how they feel, how the person you're talking to, how do they feel, and encourage them to talk. Focus your attention on them so they feel like you're interested. There's a man named Robert Kayat. Robert Kayat was raised in Moss Point, Mississippi, and went to Ole Miss, played football at Ole Miss, then played pro football at Ole Miss, came back and was the dean of the law school, and then he was the chancellor at Ole Miss. And he was a charismatic man. When you were with Robert Kayat, you thought you were the only person in the world. He had that ability. Not many people have that kind of charisma, but that's what you're looking for here. You can't get this. If you're trying to talk to somebody who's upset like this, you can't get distracted. You can't say, oh, I got a phone call. You have to ignore everything and make them feel like they're important and that you need to talk to them. You fixed it? You think so? All right. So things to do when dealing with a potentially violent person. We're repeating this now. Maintain a relaxed, attentive posture. And I didn't know this until the first time I was across this. You don't want to get in front of that person. MSP people know all this already. Yeah, I know it. Mississippi security people, they know these things. You want to be at a right angle to the person. So you do not want to be where you're looking at them. You don't want to confront them. You don't want to put them in where they feel like they're trapped in some way. You want to stay to the right, talk to them from the right side. Doesn't have to be right or left, but at a right angle to them when you talk, and you don't get in front. Ask for small favors to begin with. The most common thing is, hey, let's go over here and sit down. Let's go over there and talk. Don't try to do everything at once. Be reassuring. And this is more important. Make sure you know in your mind that if something goes bad, you have a place to run. You need to know what your exit strategy is. I know when I first heard these, it dawned on me in my law office, like many of you, I'm at my desk and the door is on the other side of the room and people come in and sit in front of me. And if I had somebody who got upset, I'd have to get through them to get to the door. And so now I make it pretty much of a habit. I take clients into the conference room and I sit next to the door and they sit on the other side. It's just it's a really good habit to acquire, even though you're sure the people, that's not going to happen, but it's good practice to have. Even though you want to do some good, even though you want to help and you want to resolve this, don't be a hero. Don't get yourself shot, obviously. Your focus should be to divert aggressive individuals, keeping others safe without putting yourself in harm's way. Don't make any promises to this person you can't keep. Your credibility is all important. And do not touch them. Do not, and I would have that, I'm more likely to want to touch somebody. It's okay, you know, pat them on the back and those things. Do not touch them at all. Now, click it, thank you, sorry. This has got to be another person. So the first person is trying to deal with the person who's there. You should have procedures to address this. Another person needs to know how to dial 911, how to call somebody for help, how to get people away from the scene, some kind of organizational people to get them away from the danger scene, secure the area. And again, they repeat this a million times. You need to stay calm. After the violent, so then we're moving to the next phrase. We've now addressed it. We've gotten the person to hand the gun over. We've gotten them to sit down. We've called an ambulance for them or the police for them, both. I guess it depends on the circumstances, and that they're gone. Now we're dealing with advice and suggestions on what to do in the aftermath. So after the violent incident occurs in your workplace, it's important to know there's steps that need to be taken. We're going to go through these 3 steps. Immediate recovery. Anybody who was involved in this crisis, you and any of the workers that were there and saw this, let's give the hypothetical that the police came and they shot the guy right in front of everybody. So it's really upsetting. People who were involved in that are going to go through emotional stages of varying degrees. It's important to recognize what stage they're in so that you can understand. Stage 1. Employee experiences emotions, shock, disbelief, clerical numbness. Employees in the fight or flight mode, heart rate goes up, sensory perception, adrenaline flows. Step 1. We're all going to go through that if this happens. Step 2 is the impact stage. It starts sinking in. And sometimes people have a variety of things: anger, fear, rage, grief, sorrow, guilt, depression. The stage may last a few days, it may last a few months. We just get other things. Stage 3 is reconciliation, which means at some point in time, you hope, and it does really happen. At some point, they reconcile this and they move on with their lives, and it's the way it should be again. Then you've got your people taken care of, you've got programs in place. You should then go back and review what happened and evaluate how it happened and look for things that are you can improve on. I know I prepare people for depositions, and there's always, you could ask a question when there's some kind of accident. Could you have done it better? And in the deposition, I coach them to say no, because it creates legal issues. But so this isn't, could you do better, but look at it to determine if there are things that could have been done differently that from this point forward, you can improve. And it's kind of the same, but I'm not going to allow it to be the same, but you should do this. Have this evaluation, have suggestions, and this says suggest to upper management things that you could have done after you've done your evaluation. Step 3 is EAP, Employees Assistance Program. Here in Jackson County, there are several agencies that provide employee assistance programs. Singing River Services is one. I'm the attorney for them. Singing River Hospital offers that same program, and I believe there's some other vendors. The employer then will pay so much a year, and for that, Any employee who is in need of some type of psychological or psychiatric help can get free services for a period of time. And then they can deal, after they get the first free services, they can deal with whether they can go farther with it, whether they have insurance to cover it, and those things. Those EAPs are not that expensive, and a lot of companies here in Jackson County already have them in place. Your company should consider that. If you don't have an EAP program in place, it can certainly help everybody. Now, we're going to switch gears again. Let's move right along to what could you do to protect your company from these type of crises. So you should have security procedures in place in advance. It's important to have a plan on how to handle them. When developing you need a prevention plan. It's important to know who to contact and how to contact them. Once you have a plan, that should be distributed so people have the 911 and other people to know on their phones or at their desks, or who to call so they know it in advance. You should ensure employees are aware of the procedures and the safety measures before they're placed in potential risky situations. Identify security concerns, situations, areas, workplaces that are more likely to create those kind of responses. So you need to look over your plant, your physical plant, and determine, are there parking areas that are too dark that you need to put lights on, which is something you need to think about. Are there areas where employees work alone? Now, sometimes you can't help it. Security sometimes has to have one at a time, but many times they do you two at a time. That's a lot better than one. Your front desk reception area, is it something you can do more to protect? You know, and our law office is wide open, but a lot of offices I know, new law offices, medical offices, you'll see, you go and sit in the waiting room and the receptionist is behind the glass. So, and there's a door, but that door stays locked until somebody comes in. And maybe we got to go to that. You know, it's a sad comment on society, but it's something to think about. This is the one I think is the common theme. HR people can review the termination meeting. That is, all of these people were fired or about to be fired, and that's when they went and got their guns. And so we in HR need to look at ways we can improve that process. I hope I don't step on anybody's toes, but I know there are employers that when someone's laid off, even not terminated for cause, they do it in the middle of the day and they bring security in to walk them out. And that just seems to me to be the opposite of everything these slides are presenting, to create this uncomfortable feeling when even if they deserve to be fired, most certainly there's not any reason why they need to be treated with the respect. I mean, I've worked in the criminal world, and good police officers treat the criminals that have done the worst things in the world. 3 mass murders, killed their mothers. They still treat them with certain humanity, respect that needs to be recognized, no matter what the crime is or what the offense is. And I'm not suggesting that happens at any employer that I'm talking to today. Go back over your procedures, your call for help, call for medical assistance, emergency escape places, safe spots where people can go. You need to be able to account for all your employees, make sure you know where they are, and secure work areas after the event. And many of your employers here may have these already in place. Have drills. Workplace violence drills can be done if you really want to go to the end of this idea. So I want to go back now to those 3 employees that we talked about earlier that I introduced to you. So with the California shooter, the question is, what could have been done differently for this guy? I mean, he was disgruntled. He's a quiet individual, so people didn't know much about him. But he said that he didn't know why he was fired. Now, he may have been lying. We don't know. They may have explained it in all kinds of detail, but certainly it is important when an employee is terminated, they're given every opportunity, and good companies are already doing this in writing. This is why you're being terminated. Allow them to write a response. If they have a response, you want to try to give them this opportunity to say their piece. Otherwise, there's a higher risk they're going to go to the car and come back to say their piece with a piece. And so you want to be careful with that if you can. Mr. Cassidy, I mean, this guy it was everywhere with him, right? His ex-wife said he had anger issues and became angry. He didn't like where he worked. Had a pattern, this is the one, he had a pattern of insubordination, verbal altercations. He had 4 of those. Disciplinary action was never done at all. So in his subconscious mind, he could get away with anything. And so if that's an HR issue. Mr. Bing worked for Walmart, good employee, but he was known to be hostile. Well, that's one of the checklist things we saw earlier, was knowing if you know that somebody's been hostile. His death note, he repeats that he was led by Satan. He was kind of crazy, but those are that he says he was mocked by his coworkers and that his phone had been hacked. Well, I'm assuming, I could be wrong, but I'm assuming reading between the lines that when he was mocked, nothing was done about it. And when his phone was hacked, he complained and nothing was done about it. So those are the kind of big red flags that if it comes across your desk, is something to consider. On the other hand, everything's got to be balanced. Remember, the employees have rights. You can't tell them too much what they do. They have rights. You can't lie about them, say things bad about them as an employee. You have exposure to a libel action and slander action. And of course, if you know that they have a medical issue for which they're protected under the Americans with Disabilities Act, if they're protected, if they're a qualified individual with a disability, and I've got the quote from the statute, if they have a disability or a record of disability, or they're regarded as being disabled, then you have obligations as an employer to be sure that they're not discriminated against because of that. And that could come up in the same situation. You have to remember that as a balancing piece. So in summary, workplace violence is an assault, other violent or a threat that occurs is related to the workplace. It entails a substantial risk of physical, emotional harm to individuals or damage to property. Workplace violence can occur from a number of sources, including coworkers, customers, and family members. Warning behavior can be a history of violence, threatening behavior, intimidating behavior, increased stress known to them. The employee have an increased stress, negative personality characteristics, marked changes in the mood and behavior. I think that's a big one. Changes. If you have an employee who's acting one way and all of a sudden or slowly over a short time changes to be hostile, to be yelling, to be angry. Those are things that need to be recognized, or they're being socially isolated. If you have a problem and you have someone there who is acting out, then you assess first what you're going to do. Really important. You project calmness, also important. Be patient, be empathetic. Focus your attention on the person so they feel like you're the only person in the world when you're talking to them. Maintain a relaxed and attentive posture. Stay at a right angle. Ask for small, specific favors. Be reassuring. Point out choices for them. And then remember that you want to know your exit. If you have to leave, you want to be ready to figure it out where you're going when you're talking to this person. Have in place security plans, how to contact 911, how to get people away from the scene, how to call the medical if you need it, how you secure the area if you need it. Be sure to protect the rights of persons, as I just said. They're protected under the Americans with Disabilities Act. Don't libel or slander them. After the accident, after this incident, remember these stages that we talked about, having recoveries, having evaluations, and having an EAP program. I really recommend that be considered. Have workplace procedures in place. You're going to develop those, and we've covered that before. Any questions? Yes. All right.
Well, I guess I have 2 things. As a manager or a supervisor,
Very difficult to answer that question. Not too much, but enough is the answer.
Can you repeat
I-
that for the
I
folks
do.
online with the question was?
The question is, these slides say you need to get to know your employees more. The question is, how much can you know more? How far can you go to investigating their personal lives and their personal issues? That's the question. And the answer is, it's a great question. Not too much, but enough is the answer. You don't want to infringe on their rights of privacy. On the other hand, if you study most of the things they're talking about, these are things that they share with other people. They share with their coworkers, most of them. So it's talking to people about them would be the best thing. I don't think you don't want to confront them or accuse them of anything, but I think that you need to learn about them, because if they say it to other people, it's public. So you can gather that information. And that's where I would start. I would coach supervisors to talk to their employees, all of them, about how they're doing and what they're doing. If this person doesn't volunteer it, then you can ask others, if you heard anything, what has he said? That's where I would start with objective criteria that there's an issue. So I wouldn't just assume that there's something wrong. But if you have an employee who's changed his behavior, now he's acting out in any of these ways, saying things about, I'm talking to you and I'll kill you if you don't listen to me. You think I know there's this line about, I've got a secret, but I won't, if I tell you, I have to kill you. All right. Well, believe it or not, I think that's a checklist thing. That's threatening somebody's life. Now, in that context, that's not much, but that's the best that I can do for you. You need to learn about your employees to protect you and the employer and the workers. How far can you go? It's got to be something reasonable would be the answer. And that's always reasonable in the law is always a difficult thing to answer. Does that help?
Yes, and I found my other question. Recognizing violent potential has obsessive involvement in your job. How do you define that? Because you've got 24-hour workers that are constantly thinking about their jobs, but then what do you mean by obsessive?
The question is, one of the things on the PowerPoint is you should recognize as a checklist, as a problem, is where employees who are obsessed with their job. They're talking about an extreme. They're talking about somebody who's supposed to clock in at 8 o'clock and shows up at 5 in the morning. You have somebody like that? You get there at 5 in the morning? Well, I hope when you get there at 5 in the morning, you go home at like 3 in the afternoon and not work till 10 o'clock at night. No. Well, even if it's you, that's a check mark. If you're really getting there at 5 in the morning and you're leaving at 11 o'clock and you're leaving at 10 o'clock at night, that comes into something that's a check mark. Now, before you declare yourself in need of mental treatment, I think there would be more factors than just that. But the word obsessive is a medical term, and I'm not a doctor, but the obsessive idea, and you can usually tell that it's just somebody who is going too far than way beyond what their normal job would be. And most of the time, I would think that you'll see other factors that show that obsession is not good for them and not good for the company. That's when you do something, when you recognize that there's something that's not good for them or the company. Does that help? Anybody else?
I was gonna say, as an add-on to that comment, I would think most people who would qualify as obsessed with their job, they also project that to other employees. They're not doing what they should be doing, and they're fussing at other employees about stuff because they're obsessed with the job. They think everybody should be, and if they're not, then that creates, usually it'll manifest itself in some discussions and stuff. So
Those online didn't hear Sandy's answer, but she was adding on to the fact that a person who is really a problem of obsession, you'll find that they're not just obsessed with the job for what they do, but they're going to be critical of everybody else who's not working, quote, as hard, quote, as they are. And that's another objective criteria to recognize that we have an issue that may need to be addressed. Any others? All right, well, I'm going to turn the podium over now for all of you to learn about marijuana. Tristan Armer.
You want to go ahead and launch me regularly? I think I figured out why. Is something. All right. Is there anybody here that has attended this seminar before? Okay, I know some. All right, and then have y'all been here the last 5 years? I know some folks are pretty regular. Okay. Starting about 5 years ago, I pulled some of these slides we're about to see from a similar presentation I did, gosh, pre-COVID. And this is one of them. And at the time, I said marijuana is spreading like a weed. It has spread. I had a slide on there where Mississippi had just passed, is it Megan's Law? A gal who had epileptic seizures, and CBD, the cannabinoid oil, helped her with her seizures. And Mississippi, I think, was the last state to come on board and say, okay, CBD oil is okay. And to me, I said, it's coming. And sure enough, we had the constitutional amendment process. And when we did this seminar, I did a straw poll whether it would pass. And everybody sort of logged in and said, is Mississippi going to get medical marijuana? And it was a third, and a third. One third was no, it'll never pass. 1/3 is they'll pass the counter proposal the state legislature came up with, and then a third is the constitutional sort of the ballot initiative would win. But that was 2-1, yes. And sure enough, here we are. And Mississippi has medical cannabis, medical marijuana. It is going to enter your workplace. Just is. It's everywhere. And other states that have had it for a while, both recreational marijuana now in 8 to 11 states, medical marijuana in all but half dozen. Marijuana, what you do with it, how you handle it as an employer, along with other drugs, alcohol, the same substance abuse problems as employers you've been dealing with time immemorial. But the marijuana question now has kind of some unique problems. I'm going to hopefully help you, guide you to solve them, and how it fits, I guess, with the Mississippi state laws. And there's a pile of federal laws, and how as an employer here in the state, you blend them all together and sort of do the right thing. Don't stub your toe. Have good employees, happy employees. Don't run up your costs of liability or workers' comp. This is a map, by the way, and it's a little hard to see how it's labeled, but the black states are fully legalized, recreational and medicinal marijuana. The orange states are the only ones left where it is fully illegal, no medical, no recreational. The green states, they have the medical, the light green, the last two, that's what Mississippi used to be. It's called decriminalized. Minor possession of marijuana with citation, but not jailable. And then you've kind of got the gray states, and they're CBD only. They just allow CBD, and all CBD has some trace amounts of THC. And THC, I mean, again, this is all entering our regular vernacular. Tetrahydrocannabinol, there's what they call THC, pretty much 6 through 10. 9 is the major cannabinoid that gets you high. 8, I believe, will get you kind of high. 6 is good actually for the nausea part of it. And so there's these different tetrahydrocannabinol, or THCs, I'm going to just use now. And THCs, it's sort of like the alcohol in a beer. It's the active ingredient that does what marijuana does. This year, through 2022, this is Wall Street Journal article I read. American workers testing positive for marijuana reaches a 25-year high. There's a company called Quest Diagnostics. I'm not a shill for them or a plug for them, but Quest does a pretty thorough job, and their website is just a load of information. Check it out if you want to learn more about this stuff. I tend to consult with a little bit, read a little bit. They got studies, they got stats. They are a large nationwide testing company. And so they track a lot of this and they publish reports. And so that's where a lot of this information comes from. But we've hit a 25-year high. Now, 25 years is interesting. I was like, why is it a 25-year high? Well, you know why? Drug testing in the workplace didn't become a thing until the late 80s. I'll show you a little slide about that. Drug testing in the workplace has really only been around 25 years. And I can assure you, though, it's not the highest of the highs. No pun intended. The early years of workplace drug testing, workers were testing positive left, right, and center. We'll get to some of that. But again, in 2022, marijuana, after on-the-job accidents, okay, you go say, oh, you had an accident, I'm going to test you, employee, all-time high. 7.3% of all folks involved in an accident tested positive for marijuana. That's an increase at 9%, and it's been kind of clipping up at about 9% per year, meaning we would expect another stat at 10th, so another 7th. Next year will be around 8%. Post-accident drug screening positive for marijuana. And again, marijuana positive test rates tripled, right? And again, they tripled in states that allow recreational marijuana. So again, all the black states we saw on the slide, they're the ones where marijuana, the testing, positive test rates of their employees skyrocket. And again, more stats, probably a little hard to read, but you can kind of see this. This is overall positivity rate in the combined U.S. workforce. And this is for all drugs. And this is 2022 through, 2002 to 2022, the last 20 years. And you can kind of see in 2010, 2011, and 2012, that was the low water mark of what your employees coming to work that would not, when they were tested, they tested clean. That was the low water mark. And since then, it's been a steady climb. And in the bottom screen here, the bottom left, you can see the post-accident positivity, okay? So again, you get a guy who's had an accident, more and more and more, they're testing positive for drugs or alcohol. And then you can look at the last one of the positivity rates for marijuana. It is mostly marijuana is what they're testing positive for. And I think the next closest last year, it's no longer narcotics. I think it's back to stimulants. So I guess people are getting back on methamphetamine and crack and all that other stuff, I guess. So they say. So that's what I learned, that in the history of it, our dearly departed President Ronald Reagan led I guess it was his wife too, Just Say No, right? If you're a Gen Xer like me, I can sing the songs and still picture the frying pan with the eggs, right? This is your brain on drugs, right? And that movement led to Congress, the federal Congress, passing the first sort of, drug testing, workplace drug testing. And it was really just for two things. It was for federal employees and it was for DOT employees. If you drove a truck, they had a lot of trucking accidents. Again, trucking kind of really entered higher into the economy, just-in-time inventory, things of this nature. We had all our interstate systems. And so there was a lot more truck driving hours. And for some reason, truckers, when they got in wrecks and bad wrecks, man, they were full of drugs. So the DOT, and again, because it's so federally regulated, there was a lot of legal jurisdiction, if the word is correct, to enter into that workplace and say, we're going to start testing y'all. To this day, as we sit in this room today, the least bent drug testing rules for employees are in the Federal Department of Transportation field. They are still a zero tolerance from stem to stern. So if you have employees that are over the road and subject to U.S. Department of Transportation rules and regs, it is still a 100% zero tolerance for any drugs or alcohol in their urine, blood, breath, whatever. Other employment has bent in the last few years, I guess would be the way to say it. But then again, too, I wanted to point out, and I know it's a small thing, hard to see, but in 1988, the first year that drug testing kind of went, you had the federal government first, and you had DOT, and then sometime about 88, a bunch of major employers. There was a Supreme Court case, a railroad employee that had a union that contested, being tested. They're kind of a DOT regulated employment. The union said, man, that's invasion of privacy and that's a Fourth Amendment violation. And the Supreme Court said, nah, you don't have a right to work. It's, and it's a condition of employment. They want to make you wear a uniform. They want to have a dress code. They want to test your urine, make sure you're clean. They're allowed to do it. And after that, a bunch of major employers, 1988, 89, they jumped on board. Some of the early ones, again, Amtrak being kind of DOT, but Bank of America, a health insurer Signum, and the retailer Nordstrom. They were kind of the leaders to say, we're going to test all our employees, pre-employment, post-accident, random drug testing. And then it got in vogue. Other employers filed suit. And so in 1988, the positivity rate was 13.6%. So out of 100 employees, darn near 14 of them had drugs in their system at the time they were tested. So if you got 50 employees, you had 7. I mean, high positivity rates. And then why? Well, people didn't know. It was new, caught them off guard. So the next year it goes down to 12.7%. And everybody's like, holy cow, I just got fired for testing positive. And the neighbor would be like, you can do what now? You can, smoke weed on Tuesday and get fired on Wednesday. And yeah, that happened to me. So the trend then in 1990 was 11%. 91, it was 8.8, and it drops and it drops. And I cut the screen off here at 1998, but it's down to like just below 5%. And as we saw from the earlier screen, we hit the low water mark in 2010, 2011, and it was around 4%, right? That's your positivity rates. And it's since then on its way up. So what happened last year? Well, we got the Mississippi Medical Cannabis Act. And it's a pretty simple sort of act. I mean, there's about 14 parts to it. And legislation normally, and even as a lawyer, read it 3 times before I think I understand it. But I thought the statute was written pretty clearly, probably because there was so much pressure to get it and get it right. There's some model acts, if you will, from other states. We're close to Oklahoma, I believe, or maybe it's Nebraska, one of the two. And so they kind of had a good go by to start with. There's still some holes. I'll just tell you one of the biggest holes. I still chuckle at this. I won't say his name, but he's one of our state legislators. He's not mine, but he's nearby. And after they passed all this, I went up to him and I'd had some folks approach me about opening cultivation or processing facilities. And so they made all these rules. They said, hey, you can grow marijuana, you can sell it in a dispensary, patients get certified, yada, yada. You know what they didn't put in the law? Where you get your seeds to start growing marijuana. There was no provision, how to get them, where to get them, what was legal to get them. So know this, and this happened in some other states, and the term got coined, it was immaculate conception, right? The inspector comes in and says, man, is your grow room legal and all this stuff? And he never asked, where'd you get your seeds from? And it just wasn't in the law. And when I told the legislator that, I said, y'all forgot to put in where and how to get your seeds. And it's like, jaw dropped, And he's like, man, we need to amend it. I'm like, no, don't do that. Don't amend it. Leave it as it is. Let it play out. Let's see what all the flaws are before you go back into it. All right. So why would medical cannabis apply in the workplace? Kind of 2 parts of it. A, your employee, whether they have it and they're in there. 2, if they get hurt at work and it's workers' comp, I mean, how's that going to affect it? Because it's quote unquote medical. So what you need to be aware of is that your employees, to be a candidate for medical marijuana, they have to suffer from what's been statutorily defined as here comes the train again. a debilitating medical condition. And by statute, that includes cancer, Parkinson's, muscular dystrophy, glaucoma, Crohn's. I mean, these very severe, debilitating diseases. If you have it, if you're diagnosed with it, then you're qualified to be you're qualified to be certified as a patient for medical marijuana. They also include in here, quote, pain refractory to appropriate opioid management and spinal cord disease or severe injury. All right. So that is, I don't want to call it the catch-all because I think they're trying to be specific, folks that are in intractable pain. And you don't want to be an opioid addict. And if marijuana solves your problem, I take no position on it. I'm not a physician. I ain't looked at any studies, but if it's better, great. If it's not, well, it's what it is. But that's the chronic pain qualification. And so they also went further and defined chronic pain to qualify for medical cannabis. And again, intractable, severe, untreatable, persistent muscle spasms, characteristic of multiple sclerosis, or really like you take medicine that makes you feel that way, chemo, the treatment of some diseases and stuff puts you into a really debilitated state while you're trying to heal. And so those are what's covered. If you have those, you'll get certified by a practitioner as having those conditions. You then can get a card as a patient to obtain medical marijuana. The Mississippi Department of Public Health also has the ability to, by regulation, add new diseases or diagnoses that can be treated with medical cannabis. All right, now the Mississippi Medical Cannabis Act, but in black and white, clear as a bell, basically says that it will not require any managed care, healthcare benefit plan, health insurer, workers' comp insurer, self-insured insurer, any insurer like that or employer to cover the costs of medical cannabis. It says it, black and white. You do not have to cover it, not now, not tomorrow, not ever. It does not require, and it says this in black and white, any employer to accommodate or allow the use of medical cannabis or modify any job. It says as an employer, you don't have to change one iota under this act as your employer to treat your employees because of medical cannabis. You can refuse to hire, you can fire, you can take out of a job, cut pay, do any adverse action you want because your employee receives medical marijuana. Again, there's no state law that is going to trim your actions as an employer to say no marijuana in the workplace, period, end of story. I don't care if it's medical or not. Now, as an employer, we'll get to this part about should you do that? Heck, I don't know. Maybe I got some advice for you, but legally, you can do what you want as an employer. The employee has no stick or leverage over you because of the Mississippi Medical Cannabis Act. Doesn't create any legal action. There's no cause of action. It doesn't interfere with any federal restrictions, those DOT employees. Doesn't interfere with any of your federal contracting. If you do a lot of federal contracting, you have to certify you have a drug-free workplace. And again, you still can. And if somebody's a medical cannabis patient, you can sack them and keep your federally approved drug-free workplace. And again, in a different section of the act, it also says that the Mississippi Medical Cannabis Act, and from now on, if I just say Cannabis Act, it's a little easier to say. It shall not be construed to affect the existing relationship between an employer and employee or any existing law or regulation relating to such relationship. So again, they put in this act, this has nothing to do with any employment law that's ever existed. Y'all employers just march on unfazed by this. That's what the act says. Now, how many of y'all think that's going to be true? We'll cover a few of those things. We will. Again, nothing about the act can require anyone to include it as a health benefit, cost benefit, a comp benefit, or anything like that. And again, the employer is free to discharge employees, for being a medical cannabis patient, having it in their blood system, and or and take this away too. Like DOT employees, one unyielding absolute truth in every state, even California, there's nothing that allows an employee to be intoxicated by marijuana at their job or in their job. It's a fireable offense. It's for cause. So again, on-duty use is verboten in every state, federal, state, Mississippi, the whole 9 yards. Really, what this all shakes down to is, can you police off-duty use? And do you have to really, be on guard as to whether they are intoxicated on the job, and who sort of has to prove I am or prove that I am not. Okay. And that's really what a lot of we're going to talk about in this presentation is about. I put this in here just to kind of get a sense of proportion. It's a little wonky, but in Mississippi, your patients, they're allowed to have 24, they call it medical marijuana cannabis equivalency units or something of that jazz. And basically 24 a month, 28 in the possession. If you did the math, and I'm kind of English, so I know what an ounce is. I'm not so familiar with a gram. But if you did the math, 3 1/2 grams of flour, that's 1/8 of an ounce. And I don't know how familiar you guys are with sort of the street sale units of marijuana. Hey, look, I was in college once. 1/8 of an ounce is kind of like the smallest sale unit. I guess there's dime bags. Those are a little smaller. And really your 1/8 ounce is half of a 1/4 ounce, which is kind of that's sort of like the Happy Meal size. Just go in there and say, I'll take the number 1. Okay, it's a 1/4 ounce. And then, 4 1/4 ounces is a full ounce. And so if you do the math here, that pretty much equates to 3 ounces a month, which, but I guess if you smoke it every day, if you have chronic pain or you're on Parkinson's, you just smoke every day, that's about the amount. But that's what a person in Mississippi can legally obtain. One other thing too, the statute said this, it kind of caught my eye. A medical cannabis product, when you sell it, shall contain a notice of harm regarding the use of cannabis products. And I can be smart and I can say, well, I thought it was medicine. But listen, you look at the side of any bottle, any medicine you take comes with a warning. So there's pluses and minuses too. I mean, and that's just reality. There are pluses and minuses. I don't care how you feel about marijuana. There's pluses and minuses. But all medical cannabis products shall contain a warning that they do cause some harm. Right now, what we're interested into, and I got to warn you, we're good right now. Okay. See, for you all geographically challenged like my kids are, I drew an arrow over Mississippi so we'd all know where it was. But Mississippi right now has, as we just read, 0 employee protections for medical marijuana. We're a 0 state. Now, we got to look at the green states. All right. And I think there's 8 of them. They protect users, meaning you cannot fire them if they just test positive. You can only fire them or demote them from a job or take adverse employment action if they're intoxicated or a DOT employee. But otherwise, if you say, I want a drug-free workplace, 0 tolerance, you're in the wrong as an employer. Okay, that's those states. The orange states, they don't protect every person that tests positive for marijuana. They only protect folks that test marijuana and whip out their medical card. Say, I'm a medical patient. And if you're a medical patient, the doctor certifies you, then as the employer, you can't take adverse action against them. You can't just fire them because they violate your 0 tolerance drug rules. They're protected. If I had a time lapse of this map, I'd say 5 years ago, there was 1 state. And then they got to be a few more, and then they got to be a few more. Spot the trend. And so do I think this is coming? I don't know, but it's possible. A lot of states have adopted this, and 8 states protect the employment rights of recreational marijuana users. Again, off-duty use, right? Can't use it at work. Some cities have kind of gotten into the game. Atlanta, Washington, D.C., Philadelphia, these big cities, they basically have said if you're an employer in this city, we have an ordinance that says you can't take adverse action against marijuana folks. So cities are kind of stepping up and giving employee protections. 20 states, like we said on the yellow, they're saying, hey, look, medical marijuana, if they're a medical patient, they're protected somehow. Louisiana, already our neighbor. And look, I don't know anything about Louisiana law. It's Napoleonic Code. Y'all know what that is? See, all 49 states follow our tradition is the English common law, sort of judge-made law, people-made law. And then Louisiana, gotta love those crawfish, gotta love the accent and the joie de vivre. But they're the only ones that follow the Napoleonic Code. Well, so they're a little different than us. But they have enacted protections for public employees, and there's a bill there now in their state legislature. I don't know if it passed or not. It's going to protect all medical marijuana patients. So our next door neighbor. And again, some states, and these are interesting too, they protect patients not through statutes, but through the interpretation of, as an employer, you must engage in the interactive process and make a reasonable accommodation before you go against an employee's right to smoke marijuana. And boy, that sounds really familiar, doesn't it? And that is applying sort of the EEOC's long-term sort of matrix to medical marijuana. The states are doing it. And you start to say to yourself, wow, that's a pretty big clue, because how does ADA apply to medical marijuana? Now, this is where you got to scratch your head and say, wait a second. Mississippi statute said I ain't got to do diddly because I'm an employer. You're right, under state law. What does federal law say? Right? In federal law, basically right now, it says two things that are kind of helpful. The first one is that being on a substance or having substance abuse issues or whatever is not a disability, right? There's that statute. We're clear on that. We're under ADA. But it also says this too. Courts have found the ADA protections do not apply to medical cannabis because it remains federally illegal, right? See, if I have, I don't know, diabetes, and they give me a diabetes medicine and it makes me super sleepy, and I got a job where I got to be awake a lot, and I say, man, this medicine I'm taking and I can't sleep. The employer's got to go through the interactive process, right? Can I find another job for Tristan before I fire her? Well, you don't have to do that with marijuana because it's federally illegal. Okay, you have to do that for every other drug. Well, it remains marijuana is still a Schedule I drug. On July 25th, 2022, the Senate leader proposed a bill, the Cannabis Administration and Opportunity Act, which seeks to decriminalize marijuana federally and enable states to create their own cannabis-related laws. Now, they didn't schedule this for a vote, but know this. The only reason you don't have to do the ADA interactive process, if you're required to do it anyway, if you're subject to ADA due to your employment status, the only reason you have to do is marijuana is federally illegal. If they pull that pin and it's no longer federally illegal, then if you're subject to ADA law, medical cannabis patient in Mississippi, you're going to have to undergo the interactive process. All right. So literally the feds are coming. And right now, if you're subject to ADA, you're good. But if they change this and marijuana is no longer Schedule I, that ripple effect will be that you have to engage in the interactive process with your employees for medical cannabis. Medical, not recreational. All right, so some of you have been here before. If you've seen this a few times, this is how you test employees. I'd say again, 10, 15 years ago, like, remember the first case we talked about where the railroad union, they said, hey, it's invasion of privacy to be taking my urine or demanding I get blood or whatever these things are and invading my privacy. And then there got to be a trend too, where if an employer was doing it and not doing it properly, they're getting sued for defamation and slander, invasion of privacy, intentional infliction of stress, and a lot of lawsuits were being brought against employers for not drug testing properly their employees. So most state legislatures kind of passed some model acts and said, hey, this is how you should drug test your employees. And believe it or not, it's an elective. You can elect to follow the Mississippi law on drug testing or drug and alcohol testing your employees. And we'll get to how you elect and all that good stuff. I guess the big question that we touched on earlier is, should every employer establish a drug and alcohol testing policy? Now, you have to have a policy if you really want to protect yourself. You can still do it without a policy, but you are subject to the winds of lawsuits by your employees. The biggest thing is, if you have a policy and you follow this act, you have immunity. And immunity is a really good thing, because when I have a client who's immune that got sued for doing something wrong, I can walk into court on day one. I have to go through discovery. I don't have to deal with a long civil lawsuit. I can go day one and say, Your Honor, immune, case dismissed. It's the shortcut out of court is immunity. So if you establish a drug and alcohol testing policy that meets the state minimums, you'll be immune for little things that happen between you and your employee when you're testing them. The second big benefit is 5% off your workers' comp premiums. If you establish a drug and alcohol work testing or drug-free workplace testing policy, then you get 5% off your workers' comp insurance premiums. A lot of the brokers will say, hey, send me your policy. They tuck it in your file and you get a 5% discount. And that adds up to be a lot of money over time. As they showed back in the 80s, when they first started testing their employees, a more sober set of employees led to big reductions, accidents, embezzlements, workplace violence, the whole 9 yards. A nice, sober workforce beats one that's badly hungover, drying out from drugs, or high as a kite. I mean, it's just pretty obvious, a conscientious workforce. And the studies have shown that. There's just no debating that. That's why they put it in place back in the 80s. Should every employer test for marijuana? Right? Now, this question, so you have a drug and alcohol testing policy. What you have to have in that policy is, we're going to test for these drugs. Typically, it's a 5-panel. That's the cheap one. You can do a 10-panel, and it kind of covers the drugs of abuse, marijuana, amphetamines, barbiturates, opioids, that sort of thing. And what a lot of employers are doing out west, where they have a lot of recreational marijuana, they're just not testing for it. They just don't care. We'll test for opioids, we'll test for, coke and amphetamine and all this other stuff, but we're just not going to test for marijuana. Just leave it off the panel. Now, you could do that as an employer. If you're struggling to find employees and you want to sort of lower the standards a little bit, and as long as they're not high at work, and you're like, I really don't care, you can leave it off your panel. That may be one way to clear out some of the headaches if you don't want to insist on a drug-free workplace. But you can clear that out of your panel. I believe you'll still get your 5% discount. I mean, it's not like been tested or anything as to whether that's true or not. But I think if you have a drug testing policy and your panel just does not include marijuana, probably still get your discount. You probably can still, qualify as a drug-free workplace. You're just not testing for it. You don't have to test for everything. There's no law or rule that says you have to test for everything. So it's something for y'all to consider as you go forward. Remember this, though, safety sensitive DOT employers, you must test for marijuana. You have to. You can't leave it out. Okay. So Mississippi Code 7171 covers employer-employee drug testing and provides immunity from civil lawsuits, like we talked about. Gotta love immunity. To be immune, to do it right, you have to have a valid election, which means you have to have some written notice to your employees. If you just start today and they're already hired, you got to give them at least 30 days notice before you start putting the urine cup out in front of them. Okay. But if you have always had it in place, it starts from day one. And, again, it's the 3 kind of traditional time periods: pre-employment, post-accident, and then some employers, random selection. Right. And again, you got to give notice that what grounds you're going to give to test. All right. You have to tell in your kind of written notice too, that if you refuse to give a test, we're going to treat it as a positive test. And then you must tell the employee 2 things in this written election. You must say, hey, look, your results will always be confidential, and you have the right to test your sample yourself at your own cost. You have to kind of tell the employee of their rights, and you have to sort of tell them what the law is. You got to, but I wouldn't stress too hard about the words and languages in your policy. Look, as a lawyer, I'd be glad to look at it for you. But know this, at the Mississippi Department of Public Health, God bless them, they've inherited all this, haven't they? They have a standard drug testing policy on their website. It's free to all. And I hate to be this guy too, but I've looked at it and it really doesn't cover all the law. It could be written a lot better. But here's the beauty of being the government. They say if you just use their standard form policy you can find on their website, you're presumed to be in compliance with all regulations. Even though as a lawyer, I'm like, hey man, your policy doesn't say this, this, and this, but the statute does. I mean, but they don't care about me. Just you download the form and you've sort of crossed the minimal threshold for having a legitimate written policy. Know this also is in the statute, that once you have a drug-free workplace policy, and you've elected it, told everybody this, you're not done. To properly have a policy, you must 1 hour annually educate your employees on addiction, disease, and dangers of drugs and company policy. Train your employees to recognize abuse, document abuse, maintain confidentiality. You must also have access, or in your policy, direct an employee to EAP resources, called a resource file. That's in the law. I found over the years, it's never come up. No one's ever been sued for it. But I ask a lot of employers, do you have this? They're like, nah. Have you done any training? Nah. But the law says so. And also says that your supervisors, they have to have 2 hours annually of training. And so I suppose if you really stepped in it, you really had that incident at work where this was very, very important and people were going over the fine tooth comb of it. If you can't document you've done your training after doing your election, I don't know, there may be consequences. So that's the law. Just know it. Again, can't emphasize in human resources, if you didn't document it, it did not happen. And it's the same with drug testing policies. Man, every employee ought to sign it and tuck it in their personnel file. Period. End of story. No questions asked. Documented properly. There's no, I didn't know, they didn't tell me, blah, blah, blah. One thing in the act about immunity is collecting a specimen. I'll tell you what the act says. To collect a specimen, you got to be a doctor, a RN, a LPN, or kind of get that certification as a qualified laboratory person. Not the employer, not the manager. I won't say which court it is, but I'm really, really familiar with it recently. And they were telling me about how they collect samples in court. And I said, that person ain't qualified to take the urine and seal it. They're just not. You're going to get bid on that. So I don't know. And sooner or later, I guess somebody's going to get a lawyer and figure it out. Remember too, and most folks farm out their drug testing, hire a pro, do that. That's smart. But you got to collect enough sample to run 2 tests. I've had this issue one time. Again, the employee has a right to pay for and ask for their own test. And if you don't collect enough sample to do the second test, drug test ain't coming in. And you've now fired them without cause, and you've done this without denied benefits without cause. And, again, just, your testing company should know this, and most of them do. But on this occasion, my client got caught with the pants down. Something else under the state laws and regs, a hair follicle test is no bueno. Okay. The statute specifically says urine for drugs and breath or saliva in blood for alcohol. Now, I know some employers use hair follicle because it goes back further in time. But the problem with hair follicle is this. If Caitlin here never touched a drug in her life and I was shaggy and I keep blowing my marijuana into her hair and she goes to work and tests, she's going to test positive. She didn't smoke a thing. Okay. It's not a clean specimen. It lacks scientific foundations of a clean sample. And now people use it and it's promoted to be used, but caution, the law says don't. After a positive test, what you do as an employer, your testing company, whoever did the test, they need to freeze for 90 days the dirty urine. Right? And if they're not doing that and the employee goes to them day 89 and says, I want to do my own test, and you don't, you're going to lose. Make sure your testing company is preserving the sample for 90 days. During that 90-day period, like I said, biggest right an employee has is say, man, you know, I don't believe you, I don't do it, and they can buy their own test. Within 5 working days after a positive confirmed test, the employer must notify the employee in writing that they were positive, and here's your discipline. Okay, no telephone call. I imagine an email probably is in writing for the most part, but still, nothing like here, I told you, it's in writing, because that's what the law says. And again, the employee can require, and I did this for a lady last year, I believe, made the employer produce the written report, the written positive report, i.e. the employee just don't have to take your word for it. Okay. So make sure as the employer, when you go to take any adverse action based on a drug test, you have the written report in your hand. A copy of it can be given to the employee. Okay. If you don't do that, you haven't done it right. So then once you do that, you give them the written notice, 10 working days, the employee may submit a reason why either the positive test is not a violation of the work rules or why they didn't test positive, or shouldn't have tested positive. Most of the time, it's always that, man, I was in the car when my cousin was smoking. It wasn't me. Or I guess in Carl's case, they eat poppy seeds, right? Legit reason, right? And that guy had a legit beef. And if the employer had not done things properly, that test wasn't coming in anyway. And he's going to contest it because he did have a false positive. The employer's response for a positive test, as soon as you get the initial test, and this is how drug testing works. All right, so you send the urine to the lab, and they'll kind of do a quick test, kind of a lower dollar test. And if it's negative, they're kind of done with it. If it flashes positive, then they'll send it for the confirmatory test, which is like gas spectrometry. It's a little more expensive, but it's the double check to make sure it's truly a positive test, right? Well, you'll get sometimes the initial test results. Don't do anything, okay? If it's a safety sensitive employee, okay, don't fire them, but pull them off the same safety sensitive job. Find them some other work to do until you get your confirmatory test. Take this takeaway. Trade adverse action on a confirmatory test only, okay? Just be careful of that too. But on safety sensitive, on a preliminary, you know, get them off the crane, okay? And know this too, a confirmed test under the Mississippi law is presumed to be cause for termination of employment, and also willful conduct, both of those. And so that helps you also with your unemployment benefits. They will be denied. They don't get any. You can also, and you need to read your policy. Some employers have committed, because they use a standard policy, to provide EAP and give notice to EAP. You should, in your little written notice, okay, I'm firing you, and I also suggest here's our resource file, or here's rehab, here's where you need to go. That's probably the right thing to do, but it's also the law. So, you know, when to test. Again, we all know this, initial employment, you know, the one that gets some questions is the reasonable suspicion. And we'll cover that in a second. And then, you know, you got random selection for public employees. There are some issues about search and seizure and constitutional protections. But if you have the policy in place, there's some limits, but you're not totally prevented from doing neutral selection. And then, of course, post-accident. And if there's a post-accident drug test, what we're going to cover in a second too, make it more complicated. OSHA has sort of put their toe in this drug testing water too. We'll get to that in a second. Reasonable suspicion. Reasonable suspicion is where a bad employer gets themselves in trouble. you don't like an employee, you've heard rumors that they do drugs, you want to fire them because they were late for the umpteenth time or they talk crappy to their boss or whatever. And then you say, well, come on in the room, pee in the cup, and they either refuse or they test hot and you fire them. You're like, did it, Well, nope, no bueno. You might get sued for that. To yank somebody out and submit to a drug test that hasn't been through the neutral selection or random selection process or pre-employment or post-accident, you better have some reasonable and articulate, recorded in writing reasons for why you selected that person to give blood, breath, or urine. All right. Just like a police officer is required to give, probable cause. He's unsteady on his feet. His eyes were red. I could smell alcohol or marijuana about his person. Things of that nature. You better document before you go waving the pea cup around, right? Or you probably would get sued and you'd be in a lot of trouble. So reasonable suspicion, use it properly, you'll be all right. And you say, well, gosh darn, how do I spot intoxication? Relax. In 19 more slides, we're going to talk about marijuana intoxication, why you need to spot it and what you got to do for it, and how the world is making employers just jump through more hoops. But anyway, if you've done everything right, you've got your policy, you give it to your employees, it's been in writing, you follow the rules as, the act and old Mr. Armer here said, well, congratulations, you got a few benefits. In addition to that immunity, the employee only has a 1-year statute of limitations to sue you. So if you do it, and he stews around for at least a year and a day, he ain't got no lawsuit. If you don't have a policy in place, common law is 3 years. So, you fire some employee and he says, man, you drug tested me wrong 2.5 years ago, he could still sue you. But if you have your policy and you follow it, 1 year, 1 year only. If you have your policy, they can, they're limited in the damages that they can get. They can get, lost wages and benefits, but they can't get anything for emotional distress damages, the open-ended stuff from a jury. If you don't have a proper policy in place, then they can sue you for emotional distress, and 12 members of your community can decide how hurt their feelings were and how much money that's worth out of your pocket. So again, it's another good reason to have a drug-free workplace policy. Again, we talked about immunity and the benefit of immunity. If you do get sued and you did everything right, you call me up, you go, I can't believe this guy is suing me. I'm like, I can't either, because we're going to be in court in about 30 days and we're going to be done with court in 30.5 days. So it really matters. Now, test results as evidence. This is for like unemployment or workers' comp or other cases where you got a test result from them, or, they're mad you terminated and breach of employment contract if you have employees on employment contracts. Just remember that, and as an employer, you're probably not doing great if you're obtaining the sample. Okay. You got to have an LPA. You got to have somebody that knows how to seal the cup properly, date it, label it, put it in the tray to go to the lab. And so we call that chain of custody. And so if you're doing that as an employer, make sure your chain of custody is tight. You got to show, to a reasonable degree of probability that it was not adulterated if an issue is raised. If you do everything right too, there's a rebuttable presumption at law that the test result was valid and the results count. So if you have a policy, you follow the policy, whether it's in workers' comp or unemployment or tort, the test results are presumed to be correct. You start with a presumption, and then they have to go a long way to undo it. Know this, there's a case in Mississippi called Southwood Door, and it was an unemployment case. They fired a trucker for positive for marijuana. They did not preserve his sample. He wanted to get it retested because he said there's no way to do it. Employer's drug testing company did not preserve the sample, and the judge threw out the evidence, and he was then entitled to back pay and unemployment benefits. That's Southwood Door. So again, if you don't do this testing properly, then the test results are not evidence of anything. The employer, again, as we said earlier, pays the cost for all this drug and alcohol testing, unless the employee wants to do his, retest, and then he pays those costs. All right. Recent case came out last October. about marijuana and drug testing. And just briefly, there was this guy who's working, I think he was actually working in Birmingham. He had a Mississippi employer, contract for hire was in Mississippi, so Mississippi workers' comp law applied. And he fell on a construction job, got injured pretty bad. And they took him to UAB, University of Alabama, Birmingham, which is a first-rate hospital. And in fact, not only is it a first-rate hospital, it's probably the highest accredited forensic toxicology department in the United States. Forensic toxicologists from UAB are first rate. It's a specialized part of their medical school there that their experts are experts. And so what they do is they drug test everybody as a hospital, right? Now this employer was a construction company, so they had no drug and alcohol testing policy. They sloughed it off. And they had a comp claim. The guy was mangled. And about a year into the comp claim, they subpoenaed some records from UAB, his ER records. And thumbing through them, the lawyer went, Eureka, positive for marijuana, right here in the test. So they've been paying benefits for a year. They figured out UAB on their own tested the guy, and he was positive. And they said, well, that's it. We're pulling the plug. And the claimant filed this petition to conspire, and that was kind of the issue. The administrative law judge bounced the test, largely because the employer didn't have a drug testing policy. And there was this notion too, and it's BS under workers' comp, that if you pay benefits, you give them their medical, give them their indemnity, that somehow you've waived your right to contest it later. The law says actually the opposite. It's never held against the employer for voluntarily paying benefits, period in the story. Why? We want the employer to kind of throw some benefits out there until we figure things out, just for the sake of the employee. And if you're going to punish an employer from doing that, they're not going to voluntarily do that. So that was kind of a bad reason, but this thing got up to the Court of Appeals. The Court of Appeals reversed. And they said no benefits because he tested positive, right? And they went a little further. And they said, look, yes, this employer did not have a drug testing policy, but the employer didn't ask for the drug test. UAB did. And so we're not going to exclude it. Okay, we're going to allow it in. All right, then you get into, all right, well, he tested positive for marijuana. And this is where the claimant made a mistake. The claimant said, again, I was in the car with somebody getting high. Okay. He did not say, yeah, the Friday before the accident, I got hired, I could hunt ducks with a rake. And if he'd had said that, but 5 days later, I'm sober. It's just in my bloodstream. He didn't say that. He tried to do the old contact high thing, which lessened his credibility. And then the Court of Appeals went on to say, listen, after we amended the statute says this: if you test positive, you are presumed to have been intoxicated, and that the intoxication was a proximate cause. It's what caused you to fall that day and be injured. And you, in the case below, did not put forth any evidence to rebut those two presumptions, that you were A, intoxicated, and B, it had nothing to do with causing your accident. So you get no benefits. So as an employer, know this. Once they test positive, you got to hammer. I mean, you really do. You don't have to pay them workers' comp benefits. You can terminate them. You can take lots of discipline. Just make sure the test is right. And this Cheyenne Steel Company, they got awfully lucky. Okay, because if they'd asked for this test without a testing policy, they'd be paying catastrophic benefits. So again, this is the takeaway from the case. Like I said, Meek, the claimant, he argued correctly that the drug test was insufficient evidence to raise the presumption because the drug test results do not note specific levels of positive drugs in the claimant's system. I think we're leading to something else that I'm going to hammer on here in a second. And that is, remember what a marijuana test is. It's the test of presence. It is not the test of intoxication. They're different. But the court said, matters not. Our statute has these strong presumptions, and that's the evidence. The mere presence is what triggers the statute. All right. And then marijuana, here's another quote in the case, stuck out to me. Marijuana being a Schedule I controlled substance was illegal at the time of Meek's accident, and no mechanism existed by which he could have legally ingested it. Those are the Mississippi Court of Appeals words. If they declassify marijuana as a Schedule I drug, is that true? No. I still don't think it's going to affect state law, but man, it is going to throw a monkey wrench in federal law. And again, this is where we get into what does a positive marijuana test mean? To this day, there's no scientific basis. There's no real generally accepted science or medicine that says a certain quantity of marijuana causes a certain quantity of intoxication. They're just correlations are all over the map. People that smoke marijuana every day, they could be in this room functioning right now. You'd never know. First time smoker, you're in the corner laughing, and it's just not been correlated. The same with the amount of, and here's where marijuana testing gets a little funky. When you take an alcohol test, you're truly testing how much alcohol, the active ingredient that makes you stuporous, in the blood or breath. I mean, it's alcohol. It's the kicker. And your body hadn't digested it yet. Still rolling around, making you drunk. Marijuana is kind of the opposite. You smoke it, and right away, your body converts it pretty quickly into metabolites, the leftovers, the broken up pieces of THC. And so all a drug test is really doing is saying how much leftover pieces of the marijuana, of the THC, is left in your blood and breath. That's what we call presence. And if you look at this chart, and I know, again, it's hard to see, but if you're a chronic smoker, okay, the occasional smoker is A, right? So he smokes, and here's what his, then they call it nanograms per milliliter. So the first couple of days, he's pretty high when they test his blood, and then it drops. And about day 8, he's below the 20 nanograms per milliliter threshold of a positive test. So he smokes once, 4 days, he's clear. But we go to the other end of the spectrum, and this is a daily chronic smoker up here at the top. He doesn't smoke for 32 days. He is still popping higher than a guy who's 3 days out that never smoked. So chronic smokers will test positive for 30 days. Dude, sober for 30 days, and they're still going to test positive. You say, well, they smoked 30 days ago, or they smoked a bunch 30 days ago. What does that mean? Well, we need to, as employers, distinguish between presence and impairment. And I'll show you why in a second when it comes to OSHA. Again, presence, it's the drug, the presence of the drug does not equal impairment. Individuals have different rates of absorption. Some people are more sensitive to it, and there's a wide range of concentrations in different individuals that produce different levels of impairment. And why does that matter? Well, here comes OSHA. And OSHA says, first, no person can discriminate against an employee because the employee filed, instituted, or caused a complaint, right? This is unsafe. You did something unsafe. Or I had an accident, and I'm supposed to report this accident, but you're going to test me for marijuana, so maybe I'm not going to report the accident. So you as an employer are arguably, with all this marijuana waving the cup around, preventing me from regularly and timely reporting accidents because I'll suffer adverse consequences from my employer. And so OSHA kind of got on this and said, look, if you're subject to OSHA, which is 10 plus employees, and or if you're in kind of a particularly dangerous enterprise, and even if you have 10 or more, if you're an Appendix A employer, and it's yay long, I ain't gonna go over it, but you're a law firm, okay? I could have 100 employees, I'm not subject to OSHA because we're Appendix A unless we have a bunch of injuries and we get taken off Appendix A. But if you're subject to OSHA and you want to drug test post-accident, look out, all right? Now, the rule does not prohibit drug testing. The rule just says, hey, you can't use drug testing or the threat of testing to retaliate against employees to underreport on the job injuries. All right. So post-accident drug testing must be limited to tests based on a reasonable possibility that drug use by reporting employees was a contributing factor to the injury or illness. And we sit there and we think about marijuana a second. And what did we just go over? That test has nothing to do with intoxication. It has everything to do with past intoxication or past use. You're a marijuana user is what a positive drug test says. The test itself does not say you were impaired or that your impairment contributed to the cause of a workplace accident. So right away, OSHA's saying, hey man, this marijuana testing business doesn't fly right. But OTA got a solution for you. And that's this right here. Employers may do post-incident drug testing pursuant to a state, including workers' comp, drug-free workplace policies. If you have a workplace drug testing policy, and you've done that written election, you've got an employee to sign it, you're home free. Forget OSHA. You're all good. That's one of the other big benefits of having a policy, having it signed, having it in the file, and doing it properly. Because then you can always comply with your policy to put the cup out for your employees. And OSHA's not going to get a complaint, come down here and investigate you for why you're retaliating against your employees for reporting accidents and making them reveal that they had off-duty marijuana use. If you want to just get out of this trap, get out of this problem, have your policy, all right? Or if you don't have a policy, and it's probably still good practice, even if you do have a policy, that you got to employ that reasonable suspicion to testing your employees. Post-accident, not all accidents are the same. And this is OSHA's example that they give. If an employee drug use could not have contributed to the accident or illness, post-incident drug testing would likely only discourage reporting without contributing to the employer's understanding of why the accident occurred. Drug testing under these conditions could constitute prohibited retaliation, subject you to OSHA fines, penalties, and employee lawsuits. So what does that mean? Well, here's the example. The employer required drug testing after the employee reported work-related carpal tunnel. All right, typing on the keyboard. Does being drunk, stoned, high have any relationship to whether you get carpal tunnel? Probably not. And so OSHA said, if that's the basis, I filed a carpal tunnel claim. Here's your cup. You test dirty. OSHA's going to say that's improper, unless you have a policy in place that says we test everybody, right? So employers that don't have the policy, look out for OSHA. If you do have a policy, you're walking free. So again, the question was, did the employer who waved the cup around after a carpal tunnel injury, did OSHA consider that to be a violation and subjecting the employee to retaliation for reporting an injury? And they say yes. All right. That's how you get in trouble with OSHA. Example 2, the employee X was injured when he inadvertently drove a forklift into a piece of stationary equipment. He reported the injury. The employer required him to take a drug test. Whether you have a policy or not, is that retaliation? And they go, no. Why? Because driving the fork truck improperly, it's kind of like, yeah, there's some impairment there, the question of impairment, the question of intoxication. It may relate, the conduct and judgment may relate to causing the accident. So again, objectively reasonable test. If they're hit over the head with the falling piano and they didn't do nothing wrong, and you don't have a policy and you test them, you could be in trouble. Safety sensitive jobs, again, OSHA specifically says there's a heightened need for testing and heightened need for safety. Even if it's carpal tunnel, but it's a safety sensitive job, they'll probably give you a pass. I'll tell you this, if you're an employee flipping burgers though, no, you won't get the pass. All right. So it's not safety sensitive. Again, an OSHA rule hinges on this meaningful measurement, right? Is a marijuana test meaningful measurement of intoxication, right? So you guy gets in a carpal tunnel or some other non-judgment related accident. You say, I want to take a drug test and you test for marijuana. Does the presence of marijuana relate to intoxication? And the answer is no. We've already learned that today. So again, OSHA has weighed in and said, if you're going to test for marijuana, you better have a policy in place, or intoxication better be a part of the accident. And you say, well, intoxication. And again, here's the summary, by the way. See that dude chilling out by the dock? He's a guy with the workplace drug testing policy in everybody's personnel file. That's him. And again, if you don't have that, then you're going to deal with OSHA. That's going to be you right there. You're stressing out because you're going to then, here's the deal, for OSHA and for the workers' comp defense and for unemployment benefits, you're going to have to document signs of intoxication. And when we get to marijuana, that's a little tougher. All right. Alcohol is pretty easy to spot. I mean, you can smell it. You know, we know the symptoms of people that are drunk, right? And steady on their feet, you know, they tell you how much they love you, you know, or how much they hate you. Marijuana is a little different. And spotting intoxication is now sort of in the lap of the employer. Okay. It's like a person that serves alcohol at a bar. They have to have a little training on how to spot alcohol intoxication because you can't serve somebody who's intoxicated, right? So you have to know when is when it comes to drinks. So that's what bars and restaurants, that's the duty imposed on them. Well, guess what? If you want to drug test, hire things of that nature as an employer, when it comes to marijuana that cannot be, intoxication cannot be tested, you better learn to spot and document marijuana intoxication. This is a criminal case, but the officer in this case did a great job. All right. So facts are basically this: dude's driving down the road, comes to a roadblock of all things. And he's driving fine. But the officer kind of noticed he slowed down a little bit early and kind of crawled to the checkpoint, kind of got his suspicions up. He approached the car. He saw a little green leafy substance on the pants. He saw some ash, and in his own words, you know, the employee was really nervous, right? And then he's like, I kind of smell, you know, burnt rope, burnt marijuana in the vehicle. His speech was a little slurred. His eyes were red. And then in questioning, okay, Parrish says, okay, well, I smoked marijuana, but it was 20 minutes ago. I'm not high, you know? And that was kind of his answer. And they found the pipe inside, and, you know, obviously the pipe smelled of burnt marijuana. The officer did some of those field sobriety tests. And I'll tell you this, the ones he did, it kind of gave him a sense that the guy couldn't judge passage of time. You know, he just couldn't really, he just wasn't sort of paying attention or how long he was doing it. And that's probably the only, like a better word, stupid human trick to really spot marijuana intoxication is the difficulty tracking time. But the officer documented all this. And when the guy said, hey, I wasn't intoxicated, obviously he didn't crash his car, he didn't run anybody over, you know, nobody saw him walk and talk unsteady on his feet, things of that nature. And so it was a fact question. Did this officer properly document enough that the guy was intoxicated by marijuana? And the court said, yeah. You add all those things up, the acting of the nervous, the smelling of the marijuana, you know, yeah, he's probably intoxicated from marijuana, and that's the crime. Okay. Again, it's not a crime to drive a car with and test positive for marijuana. That's not the crime. Crime is, are you intoxicated from marijuana? Justice Kitchens had a noted dissent, and he again pointed out kind of how poor the test is. You know, it's a real subjective deal. You know, is somebody nervous enough? I'm nervous around police. I don't do much wrong. You know, it's just kind of natural. I don't know, maybe I was hanging out with my cousin who likes to smoke a little dope, you know, and I smell like marijuana, but again, I'm not intoxicated, you know? And so again, Justice Kitchens was right to say, this is a dicey way to say you are or you are not. This little chart here, honestly, if you have somebody with a bad accident, you think it's marijuana. As crazy as it sounds, I'd go through here and I'd mark down which of these signs and symptoms you see on the person. Again, you're spotting intoxication, right? And eyelid tremors. You're not really going to get a body temperature, but it's something that happens when somebody is high on marijuana. Dilated pupils, the red shot eyes, red bloodshot eyes, slurred speech. And here's the interesting blood pressure. Okay. If you take a blood pressure test and they have super high blood pressure, it's spiking. That's what happens when you first ingest marijuana. It goes away, after a while, but, laughing, fatigue, things of those nature, weird, behaviorisms. Look, the odor of marijuana. If you can document that I've smelled marijuana on them as an employer, you're probably going to succeed in showing that they had intoxication. And again, what is the legal definition of intoxication? It's what an individual lacks his normal and physical and mental faculties and is incapable of acting in a prudent and reasonable manner. And so sometimes just the accident itself and how it happened, you sit there and scratch your head and say, why did you think you could, reach that high? Or, you stacked books instead of getting the ladder that's right over there. Document the stupidity of the accident itself is also evidence of intoxication. And again, with marijuana, it's very hard to tell. Now, the Mississippi Medical Cannabis Act and the Workers' Compensation Defense know this flat out and even the statute itself has been amended to read that, quote unquote, if a positive test indicates just presence under the state law and, quote, the presence of, quote, the use of medical cannabis in accordance with the Mississippi Medical Cannabis Act and rules and regulations adopted therein, if they're a lawfully complying medical cannabis patient, too bad, so sad. You don't get workers' comp benefits. Think about that. If you know that they're a medical cannabis patient, you'll get hurt on the job. You're presumed to never have to pay them workers' comp benefits. I don't know that makes sense. As an employer, good, keeps our costs down, keeps everything, running right, keeps us from having to deal with a lot of hassles. But I think we all, as reasonable people, go, yeah, it sounds a bit extreme too, right? And I don't know where the balance is, but that's what the law is today. And again, after establishing the presumption, okay, i.e. there was presence of marijuana in their bloodstream, again, it's presumed to have caused the accident from intoxication. Those are the presumptions. But like all presumptions, the employee can rebut them. And a smart employee says, I got high last Thursday. I did it. It's me. I'm a pot smoker. But when I was at work that day, sober as a judge. And now what you got as an employer? Well, did they smell like marijuana? Did they have red eyes? Did they just roll off a break? Do they have a big marijuana leaf dangling from their rear view mirror? Were they wearing a Grateful Dead t-shirt? I mean, as an employer, it's your job now on marijuana. If you want to prevail on the defense, you want to prevail on the termination. If it's marijuana, you better document the signs of intoxication because the test ain't doing it. This is a workers' comp case from 2022, 20 years ago. Boy, we've come a long way. But a lumberjack, what do we call him? Logger. A logger, they were out in the woods, and he fell off a tree and got really injured. They sent him to the ER, and he showed 111 nanograms per milliliter. And that was probably about 2 or 3 hours, I guess, after the accident had occurred. And the doctor testified, and this is kind of laughable, but he testified that the level shown in the test was not consistent with passive exposure or distant use. Well, no, that's not true. If you're a chronic everyday smoker, 111 nanograms per deciliter is probably where you're going to come in at on test. However, this employer was pretty smart because this employer also got some co-employees to say, timeout. He kind of went off on his own at lunch, didn't eat lunch with anybody else. This accident happened right after lunch. We know he's a smoker. He's told us he's a pot smoker. And there's no way anyone would have cut the tree by climbing up it first and falling down it with a saw. The nature of the accident was ridiculous. And so with that evidence, the employer was able to prevail and say, hey, look, we've proven intoxication from marijuana. not just presence, and benefits are denied. And again, the worker shot himself in the foot because he did the old contact high. Now, while this 111 nanograms per deciliter is not presumptive proof of intoxication, the fact that he lied as to how he got to this point, I mean, you can't get to this point by the old contact high, right? I mean, he's a chronic smoker. He just didn't fess up to it. Now it's a credibility shot. Benefits, just remember, it under the Mississippi Medical Cannabis Act, 0 benefits are owed. Meaning, if the treating doctor says this guy is going to benefit from medical marijuana as a workers' comp carrier, you ain't got to pay it. As an employer, you ain't got to pay for a carrier to pay for it. You ain't got to pay it under your health plan. It isn't medicine that can be ordered through insurance or through employment, period, end of story. So again, what do you do if the treating doctor prescribes medical marijuana? Well, look, if the doctor does and the guy shows up the next day, he's going to test positive, and we know it's still no excuse for testing positive at work. So it just isn't going to work. No one's getting medical marijuana benefits under health or comp insurance in Mississippi right now. However, the trend is 6 states say we will allow employees to have their medical cannabis expenses reimbursed through health and comp. It's true medicine now. And 8 states, including us, expressly prohibit it. And the states in between, they're hashing it out in the courts. Some say yes, some say no. And I think ultimately, the states are all going to be different on this. But right now we're in the express no benefit. Some states are in the express, yes, it's a benefit. And then the rest are somewhere in between. All right, I've just blown your brain with all the stuff about drugs and testing and getting sued, not getting sued. I mean, what's the general takeaways? Today, as an employer, pick a path, all right? Are you going to have a policy? I don't know why you wouldn't. After everything you get for doing it, the shield that it provides you, make sure you have a policy, check it. Here's the thing, train on it. I mean, I know no one's gotten in a pickle that I know of for not training on it. But 1 hour a year to kind of go over your policy, your EAP, tell the employees this is how we test. You can tell them, man, if you test positive for marijuana, cannabis or not, you're out the door. Tell them, do some training. Just be on top of that. You got to choose if including marijuana in your testing panel is the way to go or not. If I ran a restaurant, Tristan Armer did, man, if they show up on time, they do a good job. It's really hard right now. I don't know if you know this. I got a client's retail, and I mean, they are dying for employees. I mean, we talk about like bringing them in from overseas to run the retail operation because they're so starved for employees. Are they going to test for cannabis? Hey, kind of dumb. They got to make a value decision, right? That's what I'd say as an employer. You need to go ahead and pick which path you're going to choose. Have a policy, either include marijuana in it, in your panel, or remove it from your panel, right? You're going to have to do that early and often. Again, medical cannabis users, they don't get any breaks from you as a Mississippi employer. Relax. Don't let employee threaten, browbeat you into it. But here's the other thing as an employer. Look you deep behind and say you got this really good employee and they got Parkinson's or Alzheimer's or something else that's really debilitating. And they're a good employee and they're like, hey man, I want to smoke the weed, and you're like, maybe it's the compassionate thing to do, maybe it's not, but you need to decide now before the accident happens or the person gets fired or those things. You need to pick your path now because it's here, it's coming. And then here's the last thing. When you hear on the news that marijuana is no longer a federal Scheduled I drug, right? Stop. We're going to have to redo this whole PowerPoint, right? Because ADA is going to apply, all right? And if they got a debilitating condition, and we saw those are severe, right? They are disabled, right? Under the law. And if the medicine is what alleviates that, man, we're going to be reasonably accommodating all of them. All right. And it's a sea change. It's really a linchpin. All right. That's the takeaways. I think that's all I got. All right. Now that I've droned on. Any questions about drugs and marijuana and getting high and all that other good stuff?
I did have one question.
Okay.
About reasonable suspicion.
Mm-hmm.
You know, the observation, documentation, all of that mess.
Right.
But report of drug use provided by reliable and credible resources.
Yes.
What if it's gossip and rumor?
Yeah, I wouldn't trade on that. See, that's, you know, here's where as a good HR person, what do, man? You talk and you listen. And so this one gal comes up to you and says, this other gal, she's smoking weed. And you go, were you here complaining about her last week and the week before and the week before? You know, she's just, at our house, we call that dropping a kite. That's a prison term for snitching and silent, and you can't do that. You can't take that word of the co-employee just because they say so. And that's why I put that in there. If they say that, just like any good police officer, which y'all have to be now as an employer. All right, now I'm going to investigate. Now I'm going to talk to the employee. Hey, look, how's you talk to supervisor? Is the work steady? Do they show up on time? You ever smell any marijuana on them? Then you get some counting. You're like, yeah, I'm not waving the P cup in front of that person. I'm just not. Now you get a couple employees and they're like, man, it was in the car, in the parking lot. I walked by and I smelled it. And that person has nothing to do with them. There's no prior things. That sounds more credible. And so it's a judgment call, and I'd err on the side of dig deeper. Okay. That'd be my advice. You don't have enough just because one employee snitched on another. Anything else?
Yeah, let me tell everybody at home, in the office, or here, we want you to fill out the little form telling us how you think we did today, but more importantly, ideas for topics for next year. We don't have them here in writing. You'll have to go online, but please do go online and fill those out for us. And then also for the credits, for those who are not here, you'll need to go online and download that form from the website. We have forms here, though, for your credits in the back if you don't need them. So I think on behalf of our law firm and of the Gulf Coast Human Resource Association, we thank all of you for being here. We can be around for questions, more questions if you have any, but we hope all of you have a great day and thanks for coming. About to go. These people leave this here. I'm about to come get it.